Good morning, everyone. Welcome to the Hive for today's first Philippine Moot Court competition. I'll be starting in a few minutes, so kindly settle down and proceed to your respective places. Thank you. Testing. One, two, three. Testing.
Check. Hey, check. One, two.
Of highlighting the crucial benchmarks of legal education. morning, everybody. We'll be starting in 5 minutes. So we hope that everybody can get themselves ready because we will begin in 5 minutes. Thank you. So, good morning, everybody. Good morning to all, to our esteemed panel of judges or bench, our participating teams and schools, officers and personnel of the Philippine Competition Commission and the Legal Education Board. Welcome to the final round of the first Philippine Moot Court Competition on competition law. Once again, my name is Simon Salinas from the Legal Education Board, and I am your Master of Ceremonies and Bailiff for today's finals Moot Court Competition. This endeavor is a proud collaboration between the Legal Education Board and the Philippine Competition Commission. For today's finals, we'll be live streaming via Facebook and YouTube from the Hive Hotel in Quezon City. It is my distinct honor and pleasure to welcome all of our viewers from all corners of the Philippines and to that extent, the world as well. From 21 schools expressing interest to participate, to 16 submitted memorials, to 8 schools participating in our general rounds, 4 schools participating in our semifinals, it truly does come down to this. Welcome to the finals of the first Philippine Moot Court Competition on competition law once again. Before we proceed, here's a recap prepared by our organizing team.
In the pursuit of highlighting the crucial benchmarks of legal education in the Philippines, as well as a keen appreciation of a free and fair market that is integral for business and commercial growth, the Legal Education Board, in partnership with the Philippine Competition Commission, brings you the first Philippine Moot Court competition on competition law. This groundbreaking competition brings together the brightest legal talents, advocates, and students from across the Philippines. Ready, set, move.
So thank you to the organizing team for preparing that recap. At this point, I believe that we should all give ourselves a round of applause for everybody for having made it this far in the competition. Now, at this point, just as a refresher, I'll be reiterating some of the applicable rules for today's competition. For today's final rounds, our mooters will have a maximum of 45 minutes per speaking round for the complainant and 45 minutes for the respondent. Each participating mooter will have at most 20 minutes to speak and another 5 minutes for rebuttal. Our judges will be assisted by me as both bailiff and timekeeper. I will function as bailiff and will inform both the bench and the participants of the following intervals of remaining time from the time that the president deems it fit to begin the moot court: 10 minutes, 5 minutes, 1 minute, and the termination of the speaking time. As for the rebuttal portion, the president will then ask the teams who among the participating mooters will provide the rebuttal. The speaker will then have 5 minutes and will be informed of the start of the rebuttal, the final minute, and the termination of the time. To reiterate, our teams will be judged on the following criteria: a maximum of 30 points for legal arguments and argumentation, a maximum of 20 points for organization of presentation, a maximum of 15 points for general evaluation, a maximum of 10 points for responsiveness to opponents, a maximum of 10 points for responsiveness to judges, and finally, a maximum of 15 points for delivery, for a total of 100 points as the perfect score. After the moot court, the judges will then deliberate and select among themselves, based on the scores tabulated and the collective wisdom of the bench, as to which team will win the first Philippine moot court competition on competition law. And with that, ladies and gentlemen, it is now my distinct honor to acknowledge the members of our bench. The first of our judges on the bench, is no less than the chairperson of the Legal Education Board, Chairperson Ana Marie Melanie B. Trinidad. Chairperson Trinidad took her pre-law in the University of Santo Tomas, obtaining a Bachelor of Science degree of Industrial Engineering. She then obtained her Bachelor of Laws in the San Beda University, where she is also currently completing her Master of Laws. After working for the Supreme Court as a law clerk for Justice Bellosilio, Chairperson Trinidad then became an associate lawyer at the illustrious Angara Abelio, Concepcion, Regala, and Cruz law offices in Acrolo in the Labor Department for 2 years. In 2002, she then joined the Parulan, Songkuya, and Trinidad Law Office, where she has been a partner for 18 years. Aside from private practice, she immersed herself in the academe during the last 13 years, teaching Criminal Law 1 and 2, as well as Criminal Law Review for most of that time in the San Beda College of Alabang School of Law. She also served as a bar reviewer in criminal law in San Beda University since 2018. Chairperson Melanie was the Vice Dean of the San Beda College Alabang School of Law from 2016 until her appointment as chairperson of the Legal Education Board. Ladies and gentlemen, a round of applause for our first judge, Legal Education Board Chair, the Honorable Ana Marie Melanie Trinidad. Our next judge will serve as the president for today's moot court competition, no less than the chairperson of the Philippine Competition Commission, the Honorable Chair, Michael G. Aguinaldo. Philippine Competition Commission Chairperson Michael G. Aguinaldo obtained his Juris Doctor degree from the Ateneo de Manila University and placed 7th in the Philippine Bar Examinations in 1992. He holds a master's degree with a special concentration in international economic law from the University of Michigan. Chair Aguinaldo is the PCC's second chairperson since its establishment in 2016. Prior to his appointment, he was chairperson of the Commission on Audit. From 2011 to 2015, he was a Deputy Executive Secretary for Legal Affairs of the Office of the President, where he also led the Investigation and Adjudication Office, formerly known as the Presidential Anti-Graft Commission. As Deputy Executive Secretary, he oversaw the implementation of integrity initiatives consistent with the United Nations Convention Against Corruption. During his private law practice, he acquired extensive experience and expertise in handling special projects in the areas of infrastructure, telecommunications, and energy. He was also a faculty member of the Ateneo de Manila University School of Law. In his practice, he is a lawyer with extensive legal, governance, and administration expertise acquired from over 30 years of professional work as a private law practitioner, government official, and professor. Once again, our president and esteemed PCC chair, the Honorable Michael G. Aguinaldo. Our next judge is a familiar face since he has graced us with his presence since yesterday's semifinals, no less than the former PCC commissioner and former LEB chairperson, Chair Emerson Akende. Once again, if I may read his credentials once again for the refresher of everybody. He has a degree in commerce, majoring in management from De La Salle University, and a law degree from the University of the Philippines. Chair Akende headed the Legal Education Board, serving from 2016 to 2020. After having been the first dean to have been appointed as head of the agency, Chairperson Akende was then appointed to the Philippine Competition Commission from March 2020 and served until January of this year. Chairperson Akende also served as the Dean of the College of Law of the University of Santo Tomas Legazpi, formerly known as the Aquinas University of Legazpi, for 14 years. He has had extensive experience in insurance and finance as board director in the United Coconut Planters Life Assurance Corporation, UCPB General Insurance Corporation, and its various subsidiaries. And as a member of the bar, he was elected as deputy governor and then governor for the Bicolandia region of the Integrated Bar of the Philippines from 2015 to 2017. Ladies and gentlemen, from yesterday to today, our former PCC commissioner and former LEB chairperson, Chair Emerson Akende. Our next judge is famed author and legal luminary, Dean Cesar Villanueva. Dean Cesar Villanueva obtained his bachelor. Let's give him a round of applause, everyone. Dean Cesar Villanueva obtained his Bachelor of Laws from the Ateneo Law School in 1981, graduating as valedictorian cum laude, and also obtained his Master of Laws from the Harvard Law School in 1989. He was awarded a Diplomate of Juris Science by the San Beda Graduate School of Law for his scholarly writings in the Philippine Judicial Academy, and has received numerous citations for his published legal textbooks, including Commercial Law Review, among others. He was a dean of the Ateneo de Manila Law School from 2004 to 2011 and remains a professional lecturer in corporation law, agency and trusts, partnerships and joint ventures, and the law on sales. He was awarded in November 2011 by the Legal Education Board with the first outstanding law dean for a consummately impressive superintendence of the Ateneo de Manila University Law School. Among his numerous other citations, he was also the recipient of the Ambassador Cesar B. Bautista Award for Good Governance in 2014, in recognition of the many achievements pioneered as the first chairman of the Governance Commission for GOCCs, or the GCG, from the Institute of Corporate Directors. We are truly honored to welcome Dean Cesar Villanueva as part of our esteemed panel of judges for today's final rounds. And now for today's final rounds, the Philippine Competition Commission has been gracious enough to arrange for the participation of two international competition law experts to provide their insight and skill in judging our moot court participants. The first of our international competition law experts is Mr. Eric D. Edmondson. Mr. Edmondson is a graduate of the George Washington University's Law School and the University of Redlands. Mr. Edmondson is a senior attorney in the Federal Trade Commission of San Francisco, where he has litigated a range of antitrust and consumer protection matters, including mergers, price fixing, false advertising, and deceptive marketing cases. He previously worked in the Federal Trade Commission's Bureau of Competition in Washington, D.C., where he led or participated in investigations and challenges to mergers and anti competitive conduct in a range of industries, including the semiconductor, coal, petroleum, consumer products, pharmaceutical, hospital, and physician services industries. In 2002, he served as a Assistant United States Attorney for the Eastern District of Virginia, where he prosecuted criminal cases and argued appeals. Mr. Edmondson has also received numerous awards for his work at the FTC, including the Louis Brandeis Award for Sustained Excellence Litigation and the Bureau of Consumer Protection Director's Award. Prior to joining the FTC, he worked at a Washington, D.C. law firm where his practice concentrated in antitrust and litigation. Ladies and gentlemen, a round of applause for Mr. Eric Edmondson, the first of our esteemed international experts on competition law. Our next international competition law expert flew all the way from Hong Kong just to grace us with his presence today, Mr. Mark Waha. Mr. Waha leads the Asia Antitrust and Competition team of Norton Rose Fulbright, an international law firm. He is based in their Hong Kong and Tokyo offices. He was previously working as a competition lawyer in New York and Brussels. Mr. Waha is a member of the bar in Brussels and New York. He is a registered foreign lawyer in Hong Kong. He is a graduate of the University of Michigan Law School and of the Free University of Brussels Law School. He is also the author of the Hong Kong Competition Law Handbook. He also publishes and speaks at conferences on competition law issues in relevance to Asia. He has participated in academic and training programs across Asia relating to competition law. And as a lawyer in private practice, Mr. Waha advises international companies on antitrust regimes in East Asia and Asian companies on global competition compliance issues, merger filings, and international cartel investigations, particularly in Europe and Asia. For more than 20 years, he has represented clients active in a wide variety of industrial and services sectors, including the solar energy sector, with a focus on advising Asian companies on global antitrust and competition law matters. He and his team's work as private practitioners has been recognized by legal directories, where Mr. Waha ranks as a leading lawyer in several Asian jurisdictions. With that, another round of applause for our second esteemed international competition law expert and part of our bench, Mr. Mark Waha. And now, without any further ado, if it please our esteemed judges and our president, Chairman Aguinaldo, I now yield the floor so that we may proceed with our finals debate and to determine who will win the first Philippine Moot Court competition on competition law.
Hello. To the esteemed members of the bench and to our participants, good morning. Today's participating teams in the Moot Court competition will be teams G and E. If everyone is settled, we can begin.
Teams, kindly proceed to your designated areas for participation.
For claimant 1, who will be speaking first? Yes, please introduce yourself.
Mr. Commissioner, my name is Ivan Aborot, and my co-counsel here are Carl Divina and Ms. Gian Romano. We shall be representing claimant, and I shall be the first speaker.
How much time will you be asking?
I shall be asking for 20 minutes and 5 minutes for rebuttal.
UK Bailiff, kindly take note of the time requested.
Noted, Mr. President.
And of course, to the members of the bench, you are free at any time to intervene and ask questions or make any um, remarks. Are you ready to proceed, counsel for the claimant?
Mr. Commissioner, I am just shortly preparing my documents. Just
Okay.
for a brief moment. Mr. Commissioner, Madam Commissioner, members of this tribunal, good morning. My name is Ivan Aboro.
Hold on. You may begin.
Good morning. On behalf of the PCC Enforcement Office, my name is Ivan Aborot. My co-counsel here with me is Mr. Carl Divina and Ms. Gian Romano. If there are no preliminary questions, I shall now proceed with my discussion relative to the issues. So there are three central issues at hand here. Number one, whether or not the profit sharing agreement constitutes an anti-competitive agreement. Number two, whether or not there's an abuse of dominant position in the market. And number three, whether or not the agreement is exempted because of its environmental benefits. I shall be discussing the first issue, and my co-counsel with me shall be discussing the second and third issue. For the first issue of whether or not the profit sharing agreement is an anti-competitive agreement, we respectfully submit that the profit and patent sharing agreement is an anti-competitive agreement. And under this argument, we submit three premises. Number one, the profit and patent sharing agreement is a vertical agreement. Number two, A-Star and its competitors operate under the same relevant market. And lastly, there's an anti-competitive agreement pursuant to the SLC test. To address the first premise, the profit and patent sharing agreement is a vertical agreement. Since the PCA does not provide for what constitutes a vertical agreement, we go to EU regulations on what constitutes a vertical agreement. EU regulations provide, and I quote, an agreement entered into between two or more undertakings, each of which operates for the purposes of the agreement at a different level of the production or distribution chain. This simply means that for purpose of the agreement, they operate at the different levels of supply chain. And in this case, for purpose of the agreement, A-Star is the one who manufactures the solar PV units. On the other hand, Bytech and Chason are the one who provided the patents. Therefore, A-Star is a manufacturer, and Bytech and Chason are providers of the license in the research and development category. Mr. Commissioner?
Don't Bytech and Chason compete against A-Star in the manufacture of the photovoltaic cells?
Mr. Commissioner, we respectfully submit that yes, initially they competed with each other. However, pursuant to the EU regulations, it is provided that for the purpose of the agreement, they should operate at different levels of the supply chain. And in this agreement, Bytech and Chason only provided the patents, which we categorized as research and development. On the other hand, A-Star is engaged in manufacturing. Therefore, they operate at different levels. Okay. So to proceed, I should now proceed from Mr. Commissioner.
You were saying that the arrangement is really a vertical arrangement, right? And what's the importance of being able to identify that in contrast to a horizontal arrangement? It's a vertical arrangement.
Mr. Commissioner, the importance is because vertical arrangements, illegal vertical arrangements, are prohibited under Section 14C. On the other hand, horizontal agreements which are illegal are prohibited under Sections 14A and 14B.
Yeah, but both of them are illegal, are prohibited anyway, right?
Not necessarily, Mr. Commissioner. There are conducts which are prohibited in horizontal and vertical agreements. Generally, they are not illegal. However, if certain conditions are present, for instance, per se, anti-competitive conduct such as price fixing and bid rigging, then they are illegal.
Right, and that's the crucial part, right? And by you taking it out of horizontal, you're trying to get into vertical, right? To defend your. But isn't it true that all three companies are actually in the manufacture and sale of these items, right? And therefore, despite the fact that A-Star has used the technology of the other two are still engaged in the manufacture and sale of these items, right? Of the covered items. And therefore, that makes them within horizontal, as a horizontal agreement.
Mr. Commissioner, we respectfully submit this is a vertical agreement. This is because relying on EU regulations, it states there that for purposes of the agreement, in this case, in the agreement, only A-Star manufacturers. On the other hand, Bytech and Chason merely provided the patents and profit pursuant to the profit sharing agreement.
You're saying, therefore, that because of the agreement, the other two companies, Chason and Bytech, no longer will use their technology in manufacturing and distributing their own products?
Mr. Commissioner, yes, because we will later submit that there's an exclusive licensing agreement pursuant where we can infer from the facts.
So the answer is yes, they still are, and therefore they're in the same category and they're in the same classification by which to say that this is a horizontal agreement. Because by sharing this, the patent, and sharing the profits, they all operate within a horizontal plane, right?
Mr. Commissioner, in this case, only A-Star manufacturers, and we submit that Bytech and Chason are only engaged in research and development. Therefore, it is a vertical agreement. While yes, initially they were competitors. However, now because of the agreement, they now operate in different levels of the supply chain. So to proceed, since you have now established that this is a vertical agreement, I shall now undergo on why there's a violation under Section 14C. But first, before we determine on why there's a violation of Section 14C, we must first determine whether or not they operate under the same relevant market. And we respectfully submit that yes, they do operate under the same relevant market. The primary consideration under same relevant market is its substitutability. And in determining the substitutability of goods, the generally used test is the SNP test. In the inquiry in the SNP test is simple. If prices rose by 5 to 10%, would consumers still purchase A-Star solar PV unit, or would they purchase an alternative, which is Philanthropy's unit or EnvironCorp's unit? And in this case, we submit they operate under the same relevant market because consumers would still purchase Philanthropy's unit instead of A-Star's unit.
Counsel, can you
Commissioner.
explain to us the applicability of the SNP test in this case, where there is no increase in price, but rather a decrease in price?
Mr. Commissioner, the SNP test is a hypothetical test. We're not going to use the facts since the facts do not provide the test, but this is a hypothetical test in only to determine whether or not they operate under the same relevant market. So under Section 24, there are factors we should use in connection with the SNP test. The relevant factor is the technological possibility. And to apply in our current case, the only distinguishing factor of A-Star solar PV unit and the patents is its durability. The story would have been different if we say that A-Star's solar PV unit is more efficient in converting energy. However, in this case, it is only durability, and therefore, under the factor of technological possibility, there is no durability by itself cannot be considered as a technological possibility. So if there are no further questions, I shall now proceed to my third submission pursuant to the SLC test.
Counsel, with respect to the facts that you're presenting on your argument that it's only the durability aspect that is present in this case. However, is it not part of the facts that one of the subsidiaries here, either Bytech or Chason, was also had also the intellectual property on a more cheaper type of photovoltaic cells? Therefore, that goes into technology.
Mr. Commissioner, it is only the durability that Bytec's patent pertains to durability. On the other hand, Jason's patent pertains to assembly, to the manufacturing efficiency patent. We submit that the manufacturing efficiency patent cannot apply here because just because the manufacturer is able to produce more units, it does not mean it is an entirely different product. Therefore, durability is the only consideration here. So to proceed, in the SLC test, we use the SLC test because Section 14C provides that it prohibits any other argument other than those specified in 14A and 14B, which has the object or effect of substantially lessening competition. While we concede that the SLC test originated from Europe, nevertheless, the PCA has adopted this under Section 26. And in Section 26, the inquiry here is that if there is an actual or potential adverse impact on the competition in the relevant market caused by the alleged agreement or conduct, then there's significant lessening of competition. So in our determination, using the SLC test, we provide the European case of Tetra Pak. In the case of Tetra Pak is the market leader in liquid food packaging. Tetra Pak obtained an exclusive license from Liquipak's technology. In this case, it was held that the exclusive licensing agreement was anti-competitive because inter-brand competition was adversely impacted by reason that competitors can no longer enter the market because of these technologies. Similarly, in our case, A-Star is the leading manufacturer of solar PV units, and they obtained an exclusive license for technologies of Bytec and Chason, which caused an adverse impact on the market because competitors could no longer enter the market without these technologies.
Counsel, can I ask you, Tetra Pak
Commissioner.
is indeed about exclusivity. Where do you see exclusivity in the facts?
Mr. Commissioner, we submit exclusivity by inferring it from the facts. For instance, after the agreement was signed, only A-Star was manufacturing the patents in the PV units. Secondly, in the investigations of the PCC Enforcement Office, it was categorically stated that A-Star, Bytec, and Chason monopolized these critical technologies. This is where we infer that there's an exclusive licensing agreement.
Thank you.
Thank you. So to proceed, because of the exclusive licensing agreement, parties are no longer able to enter the market due to the level of technology required, which was established by these patents.
Counsel, does exclusivity automatically mean that there is a substantially lessening of competition? Does the
Mr.
mere fact of exclusivity result in that?
Mr. Commissioner, we respectfully submit that generally, exclusive licensing agreements do not mean that there is substantially lessening of competition. This is where we use the case of Seeds, which originated from Europe. In the Seeds case, there was an exclusive licensing agreement, and it was allowed. This is because the party here, the entity here, was not a dominant entity, and therefore they undertook the risk to enter the market. On the other hand, in the Tetra Pak case, it was a dominant entity, which caused other parties can no longer enter the market because they have the resources in order to curb other competitors. Similarly, in our case, A-Star is the biggest entity here, and furthermore, they also cooperated with Bytec and Chason, which is why the other parties could no longer enter the market due to the high threshold of technologies required.
What about, excuse me, what about the right of the patent owner in this case? Under the Intellectual Property Code, they have certain rights that they're allowed to basically use and exploit their innovation or their invention.
Mr. Commissioner,
How do you tie this in? Because if you look at the Intellectual Property Code, they can actually prevent anyone from utilizing that patent.
Mr.
Which
Commissioner,
kind of implies that they could do exclusivity. It seems like it's a right that they could exercise under the Intellectual Property Code. How could you reconcile this with the competition concerns?
Mr. Commissioner, we agree that it is the right of the patent holders to enter into exclusive licensing agreements. However, using the Tetra Pak case, if they are already the dominant entity, and in addition, it has a tendency to eliminate all other competition, then it is then that the exclusive licensing agreement is illegal in the Philippine Competition Act.
Councillor, you are now articulating an argument under Section 14.
Yes, Mr.
Last
Commissioner.
time I looked at Section 14, there's no reference to dominance. And now you're relying on Tetra Pak, which is a Article 102 dominance case. Can you please clarify for this panel?
Yes, Mr. Commissioner. We agree that that Section 15 pertains to dominant position and Section 14 is an anti-competitive agreement. What we are simply stating here is that there's an anti-competitive agreement, there's an anti-competitive exclusive licensing agreement by taking into account the dominance of the entity. We are not saying that this is already categorized under Section 15.
Thank you.
If there are no other inquiries, I would like to conclude all of my submission. To conclude, the Profit in Patent Sharing Agreement is an illegal agreement pursuant to Section 14C of the Philippine Competition Act. This is because, first and foremost, it is a vertical agreement. Secondly, they operate under the same relevant market. And lastly, pursuant to the SLC test in the Tetra Pak case, because of their dominance and the high threshold of technologies in order to enter the market, there is substantial lessening of competition. Thank you, Madam, Mr. Commissioners, and members of this tribunal, and have a good day.
Council, do you agree that the lessening of competition can come about through technological innovations?
Mr. Commissioner, if it has a tendency to eliminate all forms of
It
competition.
does that, right? In a market, the invention of a new technology has the tendency, by one player, really has the tendency of eliminating or suppressing competition because of a superior product, right? And therefore, all that is involved here is basically new technological advances that will, by themselves, even if there was no agreement, will by themselves allow Chason and Bitech to lessen competition because they will start to dominate because people will move to their products, right? And therefore, by itself, just because it's the subject of an agreement with A Star, the use of technological advances and innovations and inventions by themselves which would have a tendency to lessen competition or in fact provide a threshold for newcomers, is itself allowed by the competition law. Is that not true?
Mr. Commissioner, we respectfully submit that there should be a balancing of innovation and competitive interest. And in this case, while yes, we agree that in the short term there's innovation, however, in consequence, all forms of competition would be eliminated. Therefore, just because there's one form of innovation, but if competition is absolutely eliminated, then in the long run, innovation would be stifled. That is our submission. Thank you and have a good day.
Can we stay on this for a second, please?
Certainly,
on,
Mr.
on
Commissioner.
barrier to entry. Isn't it the case that before the agreement, there was a barrier to entry, patent technology, and the license has actually lowered the barrier to entry by sharing the technology with a competing firm?
Mr. Commissioner, regarding to barriers to entry, it is under Section 15, which I can briefly discuss. However, I cannot comprehensively discuss, as my co-counsel here would be the one providing the comprehensive discussion. But just to briefly discuss, we anchor our barriers to entry arguments under the prices provided by A Star, Bitech, and Jason.
Thank you.
Thank you, Mr. Commissioner.
Okay, for the claimant, who will be speaking second? Yes, kindly introduce yourself.
Chair, my name is Carl Divina. the co-counsel of Mr. Ivan Abrot and Ms. Gian Romano. Um, I would like to respectfully submit that I will be explaining the two issues here.
Okay. How much time will you be needing?
I would like to request for 20 minutes in order to elucidate my points.
Okay, bailiff, kindly take note of the time requested. Are you ready to proceed, second counsel?
Yeah, yes, Chair. I'm ready to proceed.
Okay, you may begin.
Okay. Um, Chair Michael, Chair Mel, Dean Cesar, Chairman, members of this commission, good morning, and esteemed colleagues. As stated before, my name is Carl Divina, the co-counsel representing the PCC Enforcement Office. My co-counsel has presented why the agreement is anti-competitive. However, even if this commission finds the agreement to not be anti-competitive, there is still an abuse of dominant position in this case. Now, we would like to help this commission find two things to be true. First, that there is an abuse of dominant position, and second, that the exceptions that respondents are asking for will not actually apply to them. On the first issue, on the abuse of dominant position, we would like to establish three things. First is the existence of a dominant position. Second is that the abuse of dominant position is done through the imposition of barriers, not just of entry, but expansion. And third, that even if these do not apply, there is predatory pricing. On the first submission, we have to be clear what a dominant position is. Now, the implementing rules and regulations of the PCA and Rule 2G state that a dominant position is a position of economic strength that an entity holds which makes it capable of controlling the relevant market independently from any or a combination of competitors, customers, suppliers, or consumers. Now, this shows us that a dominant position has three elements. First is that they have a position of economic strength. Second, that they have independent ability, which then allows them to, third, prevent effective competition in the relevant market. Now, the first two are obviously needed, and the third is just an action that someone who has a dominant position could do. Now, since we are clear what the dominant position is, we have to next look at what a relevant market is. Now, my co-counsel has stated that they are in a relevant market. In the application of substitutability through the SNP test, or the small but significant non-transitory increase in price test, we could see that if there are changes in price, would buyers change products? And the answer here is yes. Now, what is the relevant market, so we could be clearer? The IRR, or the Implementing Rules and Regulations, in Section 2L state that the market in which a particular good or service is sold, and which is a combination of the relevant product market and the relevant geographic market. So the relevant product market here would be solar PV units, and the geographic market would be in the state, the Philippines, given that these competitors are in the country. Now,
Can I interrupt, please?
yes, Commissioner?
On the geographic aspects of the market definition, last time I looked at a map, there's quite a few islands here. Does that not affect your finding on the relevant geographic market? Would you not anticipate that there would be differences in market positions depending on transport, maybe different prices, different demand across the country?
Commissioner, we would submit that we could put those into consideration. However, we are looking at the broader scope and the broader definition of the geography with regard to the relevant geographic market in this case, because some definitions may be broad and some may be narrow. If respondent later on wants to narrow down this relevant geographic market, we will gladly accept it. However, for now, let's look at the broader market, which is the entire country, because we could look at the facts and see no specifics as to differentiation with regard to supply chains and all that.
Thank you.
Thank you. Now, there is a presumption of dominance according to Section 27 of the Philippine Competition Act when an entity has at least a 50% share in the market. Now, A-Star has a 38% share in the market, Bytec has 8% share, and Chason has a 6% share. Now, these three separately do not make 50%. However, if we add them together, they have a 52% market share. Now, why do you think we should add them together? It's because there is an agreement between these three competitors, which is the licensing agreement, as stated earlier, thus making their making their total market share 52% cumulatively.
Counsel,
Yes, Commissioner.
you do agree, therefore, in arguing the dominant position is that you put all of their market shares together, right?
Uh,
Because
yes.
because they are competitors to one another, right?
Yes,
And they have
Commissioner.
come together into an agreement, into a partnership arrangement of sort on this
Yes.
technology patent and profit sharing.
Yes,
Therefore,
Commissioner.
therefore, but according to your co-counsel earlier, he insists that this is anti-competitive because on the ground that it is a vertical agreement, right? And vertical agreement does not allow them to be in the same horizontal range. And yet, he says that you should not look at the two other companies, Chasen and Vitec, as being competitors in the relevant market. That's what he says, right? And therefore, if that's the case, there can be no dominant position because you shouldn't consider the market shares of both Chasen and Vitec because this is being looked at, the agreement is being looked at as a vertical arrangement. Wouldn't it not be more legally acceptable that you should look at the arrangement as basically being a horizontal one and
Oh.
therefore establish clearly the next item that's required, which is they do together constitute a dominant position?
Oh, we respectfully submit, Mr. Commissioner, that we could be clearer. That I agree with my co-counsel, obviously, that this is a vertical agreement. However, we have, because that it is a vertical agreement and they are in a different supply chain position, that means that the market shares that Bitech and Jason previously had in entering into this license agreement should be considered as cumulative now with A Star, because that means that they are giving their market share and their position over to A Star. So that could be considered cumulative. However, even if we don't consider the market shares, there are other considerations in the PCA to establish dominance and not just market share. Yes.
Council, I didn't see in the factual background where the agreement said that Bitech and Chase Sun stopped competing in the manufacture, marketing, and sale of photovoltaic cells with A-Star. But you're suggesting here that the agreement has ended that competition. What's the basis for that argument?
Um, if I may direct the, if I may direct this bench to the problem in paragraph 13, it states that the technologies are monopolized among themselves, which are the respondents, which is the evidence we need to show that they are actually sharing it between them. However, so that we could be clearer, this is only one factor with regard to dominance and not just market share. Because even if we don't consider market share, there would still be collective dominance. Because collective dominance has three factors. First is the ability to monitor each other. Second is tacit collusion. And third is that other competitors did not violate public policy when they found out that there's collusion. Now, where's the monitoring in this case? Since there is discussion between the parties, they are able to monitor each other since they are sharing technologies. There is tacit collusion because they are sharing patent technology in an agreement and profit sharing, which is clear evidence that they are working together, which is what collusion is. And there is no statement in the facts that competitors got angry or changed their prices in order to act against the respondents in this case.
Counsel, just to go back to that argument, cumulative market share. Based on the facts, I think the market share that we've seen pertains to the market prior to the joint arrangement between the three companies.
Yes, Commissioner.
Yes, so wouldn't be premature to conclude that there's already a dominant position, even cumulative, considering that you're basing it on figures that pertain to the period before the manufacture of these cheaper and more durable PV units.
We would like to submit, Commissioner, that what exists before and what exists after would, in this case, still be considered. Because we have to look not just at right now, but what's happening. It's not just past, present, future. It's the totality of everything altogether. Because if we look at Rule 7 of the Implementing Rules of Regulations in Section 1E, um, it doesn't just consider the market shares and one simple part, but the totality of
Yeah,
evidence.
that's true. But if you're looking at market share, relevant market share right now, you would have to factor in the effect of these cheaper PV units.
Yes, Commissioner, that's why...
So the market shares previously don't seem that relevant anymore because that was based on them. And if you follow the theory that there is a vertical arrangement here, then, and using it cumulative, then wouldn't you need composite figures for that rather than just adding up the previous figures?
Um, we respectfully submit in the positive, Commissioner. We agree with you, actually. Because that's why we are establishing collective dominance in this case. Because even without consideration of the shares, they are still acting in a collective dominant manner. However, even if we do not consider that they are collectively dominant, we could look into other means to see that they are dominant, especially A-Star. Now, A-Star has been operating in the market for 30 years already, stated in the facts. The next largest competitor has been operating for 12 years. Now, even if we find that it's only A-Star who's dominant, it would still matter in this case because given that A-Star has been a monopoly for 18 years and they're already the largest market shareholder currently, that makes them the industry leader. Thus, giving them a dominant position in this case as well, since it should be one of the considerations here. Now, how was this considered? If we look at Section 27, which determines what a relevant dominant position is. Now, with regard to what the abuse done here is...
Can we stay just 1 second on
okay.
single firm dominance with
Yes.
A-Star? Isn't the advent of the new technology and the arrival on the market of these new small players not a sign that A-Star was indeed under threat and that its position was not at all established and therefore not qualifying for a finding of dominance?
We would respectfully submit, Commissioner, that we would still be finding dominance here since if we look at the totality, again, this should be like looking at the totality of the circumstances. Just because there are new entrants that are threatening A-Star, that does not mean that these new entrants are already dominating because only 8% of them share 12%
Yeah, but my
market
point
share.
is that the 38% player was under threat and the company under threat and likely to lose a significant portion of sales if it doesn't do anything about it is not a dominant player. That's my point.
We would submit there that even if it's considered as not a dominant player, there would still be an issue in this case, given that the actions they have is still anti-competitive. Because even if they didn't, they're not actually dominant. What they are doing now is against the tenets of competition law, which is equitability. And in this case, we are looking at consumer welfare. We want to protect consumer welfare in this case. And what respondents are doing in order to protect their market share is not just beneficial to them, but also predatory to the market.
Understood. So that brings us back to Section 14 then.
Oh, yes, that's how we all tie it together.
Counsel,
Yes.
do the facts not state precisely that this arrangement has allowed the market to be, the consumers to be able to get access to high quality PV
Oh,
at a lower price than that of the previously lower price? Isn't that precisely the point of it all? That innovations, technological innovations get to be introduced into the market, get to be commercialized, so that the consumers are able to make a proper choice to be able to access better quality products at the cheapest possible price. And therefore, this has been the facts do indicate that this has been the result. And why would that be an abuse of dominant position?
we respectfully consider that, Commissioner. If these had just been the things that happened, we would respectfully concede to the respondent that they did not do anything anti-competitive, they did not abuse the dominant position. However, looking at everything that they have done, we would submit that it is anti-competitive. Because even if at the present, consumers are buying their product and but it's cheaper, it's more durable, competition law does not just look into the present. Because Section 15 states that it does not just look into current harms, but future harms as well. That's why it says it would substantially prevent, restrict, or lessen competition.
So you're saying that that in spite of the fact that technological innovations will benefit the market, and it's not being abused because the market has been able to get the benefits by being able to access quality products at a cheaper price, right? You're saying that the abuse of dominant position should be taken to what may likely happen in the future, because there, aside from this, the facts that have been proven before us, there is no indication that there has been abuse, except what you say will happen in the future. And do we take that the ability to be able to abuse itself is basis to say that they have violated the law? Is that your position?
I would say, Commissioner, that there is abuse in this case, which is what I was getting to with my next point, barrier to entry. Because Commissioner Waha was asking about barriers to entry. And that is the abuse here in this case. We are just discussing the wording with regard to future harms.
You're also saying that therefore that when a technological innovation enters the market, right, and therefore has the effect of barring entry, then that is abuse. That doesn't seem to be correct, right? Because competition is supposed to say compete, and if you cannot compete well with innovations, then you die. That's what the market is all about, right? And you're saying that because they have entered into and used innovative means, technological innovations to be able to be offered to the public quality products at a lower price, which always benefits the public, therefore, and because this has an effect of making it harder for new entrants or even current entrants to compete, then technological innovation by itself is an abuse of position.
We respectfully submit that this is not just about the technological innovation. It's about all the acts done together by respondents that is abusive. Because we concede technological innovation is good, and if that's what respondents had done, it would be valid and not abusive. We concede that if they lower their prices, lower than the cheapest competitor, then they would be valid and it is not abusive or anti-competitive. However, we cannot concede that all these acts together would not be competitive or would not be abusive. For example, driving is not illegal. Drinking is not illegal. But driving while drunk is an illegal act. That is...
You have not shown to us where the drunkenness was in this case.
Yes, Commissioner.
You just conclude that they have driven drunk. You have to show to us why they were drunk.
Oh, yes, Commissioner. That's why I will proceed now with explaining the two barriers here. The barriers to entry and the barriers to expansion. Now, the barriers to entry happens when new entrants are prevented or bottlenecked from entering the market. Now, there are natural barriers to entry, and it's not problematic for them to actually have barriers to entry. However, in this case, yes.
I'm sorry. I don't see where in the agreement that the parent company of Bytech and Chase Sun is prevented from licensing its technology to other companies as well.
We respectfully submit that they are not licensing their technology to other companies because it is exclusive, because that is what a licensing agreement is. It's exclusivity. And if we look into why they are not licensing it to other companies, we just have to look at incentives. How are they incentivized with licensing their technology to other companies? Because if we look at the facts, it is 3 companies sharing over one product, which is already the cheapest in the market. If they share their licensing and their patents with other companies, how much more less will they get? That would be detrimental to them. It is not in good business skill for them to remove their existing natural advantage over their competitors. And that's why we submit that this is a barrier and that's why it will be abusive. So to be clear why it's a barrier for new entrants. New entrants here would have to develop new technology. That's good. New entrants will have to lower the price much lower than the current lowest price so that they could fight or match it around that point, which is also good. However, it becomes problematic since they would not be able to enter if the respondents are keeping these same prices, because that means that the new entrants will be pushed out faster of the market and those other new entrants would not be able to enter as well. In fact, respondents have stated that their technology is critical in itself, which means that in the future it may be the technology for everyone else. Now,
Counsel,
yes,
you
Commissioner.
said earlier that there is an incentive for these three companies that agreed with each other to maintain their agreements or the licensing exclusive to themselves, because it is to their interest that they maintain their advantage over the others and not expand that group profiting from that advantage. However, you assume that these three in the group all share the same exact interest. Remember, the patent holders here are the two other companies, Jason and Bytech. And a naturally profit maximizing firm will try to license or will try to utilize their license to the best manner that they can. And therefore, that means they would rather license it with all other available or willing entities, because that will bring them more profits as far as this as the two license holders. So that, how do you address that?
Um, we address that by looking into the facts again, because let's make it clear with regard to the agreement between the parties. Because there are actually four parties here in this case. That the one that A-Star had actually been talking to, and the one that agreed for Bytech and Chason to share the technology with them, is the Beer Holdings, which is a Middle Eastern company. Because while I might not be able to get to it, remember, we would like to submit that since they are a Middle Eastern company, we have to also be looking into protecting our markets here in this case. And since they are they are the parent company of Bytech and Chason, and they are the ones who entered into the agreement with A-Star, it would not be beneficial to them to enter into a licensing agreement with the other companies, because they are already one of the largest conglomerates here, along with A-Star, which is also a large conglomerate. So there is actually no clear incentive as to how or why they will share their licensing agreements with others when they already have a manufacturer willing to do the work for them. Now, to expand on barriers to expansion in this case is the prevention of other competitors from increasing their shares in the market. Now, in this case, are they preventing other competitors from increasing their shares in the market? We would like to respectfully submit in the positive. They are doing it by lowering the price in a manner that's lower than the cheapest possible unit. Because this is just a simple analysis with what we have, that there are three companies again sharing over the profit of one product. If we take into account what the costing of the use for the product is, that makes it even lower. So how are these three companies sharing over the profit if they're already cheapest in the market? It is not clear in the facts. However, this is merely an inference that is educated, and if we put it together in our head, how are they actually profiting from from this just one product if they're the cheapest in the market? And even if we do not consider that they have a barrier, if that they have imposed barriers, we could also look at predatory pricing. Now, predatory pricing is when entities abuse their dominant position by engaging in conduct that would substantially lessen competition by selling below cost, which, as stated before, is an interest for them. So the elements of predatory pricing are dominant position, products below cost, and intent. Now, this is a crucial part of the discussion with regard to abuse, the intent. Because in competition law, intent is not automatically manifest. Because the wording with regard to intent here is that it would substantially prevent, restrict, or lessen competition. We want to protect consumers in this case. If we look at the four pillars of consumer welfare, where there are low prices, better quality, more choices, and innovation, at the present, there are low prices and good quality with the product of respondents. However, as time goes on, there would be less choices and less innovation. Pillars have to stand together because if two of these pillars are missing, then the structure will collapse, the market will collapse. We are not looking to put down respondent. We are only looking to protect the consumer welfare and the interests of buyers because there are always two sides here.
Council,
and supply.
you're saying therefore that in order to protect the welfare of the consumers, you will declare this arrangement to be anti-competitive, and thereby these products, which are quality products at a lower price, will cease to be present in the market. And therefore, how does that protect the consumer? The
Commissioner-
consumers now are faced with a prospect that these high quality products with lower prices than the next one are no longer available. I don't see the logic in that.
Commissioner, we are not stating that they would automatically remove their products from the market because the rules of procedure of the PCC would give fines for them and ask them to change
It's
what
not
they
the
do.
immediacy of removal, it's the eventuality of removal that's the concern here.
Now, yes, if that is a concern by respondents, then they should have acted in a manner that would not harm the market, that would not harm other competitors, and that would not harm consumers in the future.
Council, I'm looking at your prayer for relief here, and I'm wondering, why didn't you just ask the PCC to order that the intellectual property here, the patents, be made available to all competitors on the market on a fair and reasonable basis?
We would submit, Commissioner, that since we are the enforcement office in this case, that we could ask for them to do that all the same anyway. However, we are still in the administrative proceeding process. That's why we have to prove first why there is an anti-competitive or abusive act before proceeding into asking them to release their patents as an essential facility for everyone else in the market.
Okay, I think the time's up. Do you need extra time to conclude your submission?
May I be allowed like a little bit of extra time, Chair?
Yes, okay. 1 minute. 30 seconds. You have a minute.
Okay, just to conclude my arguments, I'll just go into my last issue, which is that the exemptions do not apply. There are just two simple reasons. First is that there are no environmental protection exceptions under Section 14C of the PCC. And the second is that because of that, they are not exempted because provision of law where a party is exempted has to be clearly stated. Since the respondents did not point to a positive provision of law where they are exempted, then they could not be exempted. And even if they are, they don't have substance as to why they are exempted in this case. So, concluding my speech, I would state that we are looking to see that there is an anti-competitive act, or if not, that there's an abusive act. That only one of these two have to be proven in order for the respondents to be considered in violation of the Philippine Competition Act, and that ultimately the Philippine Competition Enforcement Office is not looking to stop respondents from selling, manufacturing, or acting out in the market. We're just looking to balance interests between all parties. Because what is more likely? That they take over the market or that the market develops? Thank you.
Okay, thank you. Second counsel. Now we move on to the respondents. For the respondent, who will be speaking first? Okay, and how much time will you be asking? Okay, bailiff, 20 minutes.
Noted, Mr. President.
Yes. Are you ready to proceed? Okay, you may begin.
Your Honors, members of the Commission, good day. Before I proceed, let me just introduce myself first. I am Heidi Amabel Uy, the first agent of the respondent, and with me today is my co-agent, Mr. Abraham Lumbang. And today we will be presenting our arguments, or our submissions rather, for the respondents. So beginning, Your Honors, it must be stated first that respondent will have to reject the applicant's harmful notion that intellectual property law and competition law cannot be harmonized merely because of the exclusivity that comes from patents. But ultimately, we will also be discussing all the other arguments and contentions that were put forth therein to support this. Respondent maintains that these two laws are actually harmonized in their shared objective to encourage not only competition but also innovation, for there cannot be competition without the latter. That is why we come before this commission to submit that respondent's patent and profit-sharing agreement did not actually violate the PCA, but on the contrary, more than just helping the state to achieve its renewable energy goals, as well as providing essential consumer benefits to the Filipino consumers at the end of the day, it has also resulted in pro-competitive effects due to the dissemination of these PV units within the market, hence allowing the smaller competition, or rather the smaller competitors, to access these PV units and get a technological transfer of knowledge, or rather a transfer of technological knowledge, without having to actually enter into a patent agreement. Thus, it is our contention that when applicant states that it is required for these smaller companies to get their own patent sharing agreement or have to innovate on their own, we reject that notion. Moving forward, before I proceed with our submissions, respondent finds it apt to clarify that the arguments presented by the first agent of the applicant apply to anti-competitive mergers, despite the issue clearly being regarding anti-competitive agreements. While, Your Honors, the PCA, just to clarify, the Philippine Competition Act does prohibit, or rather has three kinds of prohibitions here. First is anti-competitive agreements. Second is abuse of dominance. And lastly is anti-competitive mergers and acquisitions, all of which have their own distinct guidelines and have their own applicable approaches. However, taking the applicant's contention still at its highest.
Counsel,
Yes, Your Honor.
do you think that it's wrong for the claimants to have or applicants to have argued points that go into that third category, mergers and acquisitions?
Your Honor, with regard to that, I'll answer it in 2 points. First, that there are applicable rules and applicable guidelines that are already available from the PCC itself that provides for.
I think the point is that it shouldn't apply the matters that they use that are applicable to the section on mergers and acquisitions. Is that your point?
Your Honors, our point is that when they use the SNP test, aside from the SLC test, it does not seem to be applicable in this case, given that we are arguing about anti-competitive agreements. Further, that
Would
the
you not
applicant.
consider the arrangement that has been entered into among the parties, the four parties, basically, whether it's oral or in writing, including a technology transfer arrangement? Wouldn't you have to consider like a sort of a joint venture arrangement or a partnership?
Yes, Your Honor. No,
And
actually, no,
therefore,
Your Honor.
and therefore is within the realm of a de facto merger, so to speak, or an acquisition of business interest?
Your Honor, while the applicant failed to actually present us with the elements of a merger, it would be respondent submission if they had presented it that it did not meet the requisites to become a merger, particularly a joint venture. Under the PCA, it has been defined that a joint venture, which falls under as well mergers and acquisitions, have three requisites. Aside from just being the joining of two or more entities, to form a a singular entity, whether that's pre-existing or a new form altogether, three requirements should be met. First, that there would be a sharing of rights to make management decisions. Second is the sharing of profits, and lastly is the sharing of risks and losses as well. In this case, it should be apt to note that the agreement here only has two components, and only one of them actually met the requisites of being a merger, which is the profit sharing portion or profit sharing component of the agreement.
Councillor, if we do not have a merger, a structural change in the market, then the agreements would fall within the scope of Section 14. Does the profit sharing agreement between two competitors not amount to a price fixing agreement?
Your Honor, respectfully, it would not amount to a price-fixing agreement, for the PCA is clear that the price fixing requires a certain intent on the part of the agreement to actually fix the price. However, in this case, the profit-sharing agreement is presupposed on the fact that they are allowing the license or their patents to be used by A-Star in order to distribute the PV units. Hence, it is more of a fair compensation at the end of the day, rather than a fixing of the price or an agreement to fix the price.
But when I share profits with my direct competitor, all of my incentives to undercut their price are gone. That is tantamount to agreeing on fixing the price, no?
With regards to that particular situation you've provided, it's Your Honors, respectfully, it would still not necessitate that the profit, or rather the profit sharing agreement here in this case, or rather the agreements among the respondents contain any stipulation, whether that's verbal or written, that they would agree that they would fix the price in order to push out competitors. Hence, even if there is profit sharing at the end of the day, still without that intention, without that stipulation, it cannot be considered as price fixing.
Yeah, Council, what's your basis for saying that their intent is not to push out competitors?
Yes, Your Honor. With regards to the SLC test that they've provided, particularly on object and effect, which we can find under Section 14B as well as C of this PCA. Object pertains, or rather the object of the respondents here can be found clearly in the facts, not just after they went into this patent sharing agreement, but also prior to this. Respondent companies, particularly A-Star, has been consistent and clear that their purpose or their objective has always been to help the state meet its renewable energy goals, as well as to provide Filipino consumers with higher quality PV units that is more high quality as well as more affordable. That can be seen under the facts wherein there was a press release as well as an annual shareholder meeting.
Council, the PV units developed using the patent apparently were a resounding success. And so presumably it captured a large portion of the market. Okay. What incentive do these companies have not to increase prices in the future when their market share increases even more? Because based on the facts, it's cheaper and it's supposed to be better quality, meaning it lasts longer and so on. So just looking at it from a simple analysis, it looks like you may be driving the other players out of the market unless they're able to innovate and compete with you then. So what would incentivize you not to raise prices in the future?
Your Honors, with this, the facts already provide an incentive in itself, although not explicitly provided. First, I'll answer your question in 3 points. The first point here is the mere fact that respondents did not already price their highly durable PV units at a higher price, or at least at the price of philanthropy energy, which they could have done given the high durability of their PV units.
Yes, but on the other hand, you could say that that would be a form of what they're doing now, which is pricing it lower. Could it be a form of predatory pricing?
No, Your Honor. With regards to predatory pricing, I'll just answer that first. Predatory pricing, much like price fixing, requires an intention on their part to actually price the product or the service lower in order for the objective, or rather, in order to attain the objective of driving out competition. In this case, the objective has not been proven by the applicant, and rather, on the contrary, the objective of them not actually wanting to drive out competitors can be proven by the 3 points that I mentioned. But before that, yes, Your Honor.
Is there any evidence that your client has been pricing below marginal cost? Do you understand that's the question?
Yes, Your Honor. There is nothing in the facts that show that they have been pricing their products below the cost of production, simply because even in the omnibus clarification statement, it shows that both Bytec and Chason actually had patented technologies of different kinds. One is of a low-cost, highly durable PV unit design, and the other is with regards to the efficiency of the assembly of this solar PV unit. Thus, it is necessary, or rather, it brings about the a conclusion that at the end of the day, it is a lower cost of production, and hence it would only necessitate that, or rather, it would be a natural consequence to have a lower selling price. If your honors is if your honor is satisfied with that, I'll proceed to answering the question from the previous honor. So. Again, with the 3 points, I already discussed the first. The second one is regarding the fact that the IP code in itself is not necessarily against or opposed competition law. And we can see this from the fact that having these patents does not necessarily purely excludes competition, when in fact, having these patents and having this patent sharing agreement and allowing that product, that technological knowledge to be disseminated into the market, allows smaller market competitors to access it without having to enter into a patent agreement at the end of the day through third-party research, which is allowable under the IP code. So on our third point, with regards to the object here, it has been consistent, not just at the start, where they have been saying to the press releases and even to their shareholders what their objective has always been, but we can also see this from their behavior right after they went into the patent sharing agreement. While they could have priced it higher, like I was mentioning, because of the high durability as well as the lowered production costs.
Counsel,
Yes, Your Honor.
you seem to indicate that in order to be guilty of anti-competition, they must declare that it is their intention to do this, that they intend to drive out the competitors from the market. All right. My first question, of course, is that when an agreement is intended to has the effect of driving out competition through pure innovation, technical innovation, that itself is anti-competitive. Is that your position?
Under the PCA, it is actually the object and the effect. So with regards to this, the effect of anti-competition cannot also be seen in the facts. Neither can it be actual nor can it be likely. That is why the applicant is correct to apply the SLC test, but not correct in applying the SNP test.
And therefore, counsel,
yes, Your Honor.
that means that the intention doesn't have to be there. In fact, declarations to the contrary, they aim to promote public welfare, does not countervail the position that was set by the applicants to say that if the result anyway is to drive out competition, which probably is in their heart, then it would be anti-competitive in character also. What do you say to that point?
I would concede to that characterization that even if they did not intend to have anti-competitive effects, as long as there was an actual or a likely anti-competitive effects, then it would be prohibited. However, the applicant here, in this case, failed to actually establish that there was anti-competitive effects present in this case, nor have they established for us today that there could have been likely anti-competitive effects. So instead, the respondent will be of service to Your Honors by showing that there is no actual anti-competitive effect, but also that there is likely not going to be anti-competitive effects. For the
Counsel,
actual...
when you
sorry, yes, Your Honor.
when you do so going forward, could you please help the Commission understand whether you are articulating arguments under Section 14 or Section 15 of the Act? This Commission will need to implement these two and take a decision on these. So it would be useful to inform our decision. Thank you.
Of course, Your Honor. So first, we are discussing Section 14C. Since we've already discussed object, and since there has been non-substantial to respond on effects by the applicant, with regards to actual anti-competitive effects, nothing can be seen in the facts. So we will only be discussing the likely effects here. Respondent maintains that there is no likely anti-competitive effects, but rather, on the contrary, there is likely pro-competitive effects. It can be seen in the facts that the solar energy industry has long been stagnant, and it has been facing issues on accessibility as well as the quality of their PV units, which has stagnated the industry for some time now. This is until, of course, there were rumors of a new patent that could potentially drive innovation, that could potentially improve the products. And it was proven true. So with this regard, while there was a patent and it was exclusive, the patent belonged to both Bytech and Chase Sun, both of which have a low market share under paragraph 5 of the facts. So with this regard, having such a low market share means that the dissemination, or rather their manufacturing capabilities, will not be as great as A-Star. And hence, A-Star leveraged their manufacturing capabilities to be able to get a patent sharing agreement, thus disseminating the PV units, the new PV units, to the market at a larger scale. That is why, in doing so, not only do the Filipino consumers benefit to this mass scale distribution of cheaper and more high quality PV units, but the competitors themselves likewise benefit from it. That is because at the end of the day, these smaller competitors who would not have been able to negotiate, because of lack of leverage, a patent sharing agreement, can now access these patented technologies through just simply purchasing the product in the market because it is now available and conducting a third-party research. This allows for not only them to be competitive and to innovate, but also protects the right of the IP holder, which at the end of the day allows the innovator to be fairly compensated and to encourage innovators further to provide more innovations into the market. Because in applicants' contentions, it would seem that the mere having of IP rights, or the mere using of IP rights, already connotes an exclusivity that they argue is already anti-competitive. However, in our end, we want to encourage not just competition, we want to encourage innovation. So with that being said, I will now move on to Section 15 on dominance. So with regards to this, the applicant contended that they would be using the 52% of the market share, the collective dominance, and the basis for this is just simply adding up the market shares. However, it should be noted that adding up the market shares requires that two things are present. First, that there is a merger and acquisition, which they failed to establish, as we have mentioned. And second, that there is control, which also was a failure on applicants' end to establish. But assuming that we can use the 52% here of collective dominance, this is still a rebuttable presumption at the end of the day. Thank you. Sorry, Your Honors, can I have
Counsel,
10 seconds?
go ahead. Take a sip.
Low sugar.
Counsel, do you not agree that you're arguing before this commission in behalf of all three respondents?
Yes, Your Honor.
And is it not true that all three respondents agreed to submit these issues jointly as co-parties, so to speak, co-respondents, therefore? And therefore, is that not clear, therefore, that together, they have acted in courts, and therefore their market share should really be considered to be the whole 52%, right?
Your Honor, even assuming that we can use the 52% here, there is still the issue to be had that dominance in itself under the PCA is not really the one that's being prohibited under Section
That's
15.
just the point. I wanted to get over the argument that they don't represent 52% of the market share,
Yes,
so
Your
that we
Honor.
go to the more important aspect.
Thank you. So, with regards to this, Your Honor, on abuse of dominant position, the applicant only contended that there was predatory pricing, which we've already established with you a while ago, that it could not be the case, given that there was no showing of an intent to fix the price for the purpose of driving out competitors. Hence, predatory pricing cannot be considered.
Counsel, if my memory serves me right, I heard arguments on barriers to entry in addition to predatory pricing.
Yes, Your Honor. Thank you for reminding me of that. For the barriers to entry as well as the barriers to expansion, which applicant contends, again, these barriers were not necessarily substantiated. First, it's not actual barriers that exist currently, nor have they proven that there would be a likely existence of barriers. And if they had, we have disproven that by stating that these barriers to entry and expansion cannot possibly exist for the mere fact that the dissemination of the PV units in the market already allows the competitors to access these PV units, conduct their own third-party research, and innovate on those products. And in so doing, that actually creates a pro-competitive environment.
But is the fact that we have this fantastic technology that is taking the market by storm and wiping out all competition not the creation of a barrier to entry? Should there not be access to that fantastic technology?
With regards to access, as we have provided, Your Honor, there already is existing access. They could access this through the third-party research. In so doing, the third-party research, this not only allows us to protect the IP rights of the patent holder and allows us to encourage innovation later on, showing that anyone that innovates will be protected by our laws, and hence they do not have to be afraid of showing this technology to us. But also, at the end of the day, it allows us to disseminate that technology, that knowledge, to the smaller markets without having to necessarily step on the rights of the IP holder or the IP right holder. So, in this regard, there cannot be any barriers to entry. And in fact, on the contrary, given that these patents exist and it is now in the market, newer entrants can actually use it as well to conduct their own innovation. And having that innovation is actually, as respondent will maintain, is the heart of competition in itself. Having this innovation does not just allow competitors to continuously provide Filipino consumers with better products in a sustainable manner, but also allows us to prevent any substantial lessening, restricting, or preventing of competition. So in that regard, there cannot be any abuse of dominance. Sorry. And then further, even if there was abuse of dominance, there are actually exceptions provided by the PCA itself. And I will be discussing this. First, with regards to the exceptions on abuse of dominance, it is exempted when it is arising from their superior product or process. This is evident here, given that the patented technologies allowed for higher durability and lesser selling price. Next, if it is because of their business acumen, if it's arising because of their business acumen.
Counsel,
Yes, Your Honor.
the argument that you're proposing that this is because of a superior technology will apply, I can understand it will apply if it is the innovator himself. Here, it is not the innovator that is utilizing that technology, but rather the more established and the more leading company that access that technology through that licensing, which makes it, as the position of the claimant, which makes it an abuse of dominance.
Your Honor, with this regard, it is not necessarily that A-Star took the patents from Bytech and Jason, but that Bytech and Jason themselves and their parent company allowed A-Star to do so. And this does not preclude them from actually benefiting from this given the profit-sharing agreement. Hence, although it's not them in itself that really distributed, it must be noted that normally in commercial activities such as this, especially where the firms are profit maximizing, Bytech and Jason could naturally conclude that them on their own distributing these products not only distributes it to lesser consumers because of their lower manufacturing capabilities, but also would result to lower yields or lower profit yields for them at the end of the day. Hence, it is just business acumen as well on Bytech and Jason's end, especially the beer holdings, to allow A-Star to do it for them. But again, just to note, there's no exclusivity here. Not only because nothing in the facts show this, but also because the smaller market competitors can still access it through the markets. And finally, that is within their legal rights, which is the last exception that I wanted to talk about. Because IP right and competition law should be harmonized at the end of the day, and this is this is where respondent wants to end its submission on that note for the first and second issues. So if there are no more questions from your honors, I will now defer to my co-agent to continue the issues, or rather the arguments for issue 3 and issue 4. Thank you, and may it please the commission.
Okay. Thank you, First Counsel. We now
Thank
move
you.
to the Second Counsel, who will be speaking.
Good day, Your Honor.
Yeah. How much time will you be needing?
I will be using 20 minutes
20 minutes.
for the discussion.
Bailiff, kindly take note.
Noted, Mr. President.
Are you ready to proceed, Second Counsel?
Yes, Your Honor.
Okay. You may begin.
Good day, Your Honors, members of the Commission. I am Abram Andrew Lumbang, the second agent of the respondent. I will be discussing on issues 3 and 4. However, I have noticed that probably due to the lack of time or the lack of intent of the applicants, they were not able to discuss this. So I will be discussing it based on our memorials and the facts as laid out in the case. Furthermore, Your Honors, I would like to clarify that this case does not require persuasives. I noticed that the applicants has been continuously speaking of foreign laws and foreign cases. A basic principle in statutory construction suggests that if there is a clear line on interpreting the law, there is no need to use any other persuasives or secondary sources. And that is why in our submission today with regards to foreign collaboration, we will be discussing the laws pertinent that is currently in the Philippines today. Proceeding to the first argument, Your Honors, we would like to humbly submit on the issue that there is no prohibitions with regard to foreign and local entities collaborating with each other in relation to the PV units. In this particular backdrop, I will be discussing 3 important points. One, yes, Your Honor.
Counsel, perhaps the Philippine Competition Act is what we call nationality neutral, right? It applies to both. But you have a constitutional provision that mandates that the state shall provide protection to local businessmen. Here, the competitors of the 3 who against foreign competition. And therefore, shouldn't that be also taken into consideration? That constitutional mandate to protect the local competitors here, many of them are not dominant at all from such foreign competition, because the agreement is really between a local company and a foreign company, right? The beer.
Your Honors, I do believe, and the respondents do believe, that that particular information regarding the Constitution is true. But in this case, what we have is not necessarily a competition between foreign entities and local entities. It is a collaboration at the end of the day. And as a matter of fact...
But we're not talking about the collaboration among A-Star, Bytech, and Choisem. It's the 3 of them representing a foreign entity and A-Star against the other competitors in the field. These are all local competitors, right? It's the small competitors that we're talking about. Not the collaboration among the four respondents, in fact.
Yes, Your Honor, we honor that. But however, we have to refer to the applicant's brief statement a while ago that there was a prohibition with regards to how foreign entities would now invest here in the Philippines. That in one of the points that I should be discussing in relation to the backdrop of the first issue, that the Philippine Foreign Investment Act clearly states that foreign collaborations and foreign investments are allowed here in the Philippines. As a matter of fact, we allow 100% ownership of foreign investments or foreign entities here in the Philippines. Only with a particular limit, that being in relation to national defense, in relation to public morals and public health, and if a particular market already has local entities that can supply. However, this is not present in this case. We're talking about renewable energy. It's not national defense. It is not public morals, and definitely not public health, because that concerns only on drug issues, if we will refer to that particular concept. But most especially, it is not about the local, as you were asking a while ago. It is not about local or a particular market that is currently controlled by the local businesses. Because at the end of the day, if you look at the facts of the case, even before the issue arose, we have Biotech and Chisan, which already are receiving foreign investments coming from an international holdings, Your Honor. So it's already part of the market. So they may not argue this particular concept that it is indeed prohibited. And as a matter of fact, Your Honor, I would also want to refer to you to a DOE circular which specifically said that renewable energy sector are allowed to have 100% investment. So there is no question regarding the investment per se. Moving further, Your Honor, to the contention of the applicant, I would want to highlight that what we have here is a technological transfer agreement. A technological transfer agreement between Biotech and Chisan and A-Star Corporation. Now, in relation to a TTA, there's only one pertinent law that we can refer to, and that is the Intellectual Property Code, which discusses how a TTA should be applied here. And apparently, in relation to the concept of anti-competitiveness, we have a particular section on prohibited clauses. And it includes only 3 points. Number 1, if there is a supply manipulation, if there is a provision on price control, and third, if there is extreme exclusivity with regards to the patent. As explained earlier by my co-agent, Your Honors, there are only 2 particular provisions that are present in the facts of the case. One is that there's a technological transfer, and another one is that there's a profit-sharing agreement, none of which talks about manipulation of supply. None of which as well talks about the cost that the product would be released in the market. And more exclusively, they might argue, of course, that there is exclusivity to that particular agreement. But then again, as I would like to point out, there is no exclusivity clause that is included in the agreement that was created by these 3 companies, by our respondents. And as a matter, yes, Your Honor.
Counsel, how do you respond to the claim of the CEO that there is actually exclusivity because the facts show that they are monopolizing the market insofar as these technological advancements provided by the licensing agreement?
Your Honor, that is why in regards to this question, there is no monopoly of the patent. Why? Because no less than the Intellectual Property Code specifically states that even if a patent holder shares a patent with another entity, it is free to actually share the same to other companies. And what we also have to take note, Your Honors, is that what we have here took 1 year for A-Star to create. Yes, it's difficult to create the patent, but it now gives a particular structure for other companies to come to to come to Biotech and Chisan to have the same patent agreement. They're paving away the chance for other companies to know how to get the patent. And moreover,
Counsel.
Yes, Your Honor.
Now, that is, of course, your contention. However, how do you go against what is apparent in the conduct of the parties? The conduct of the parties shows that they're monopolizing. So clearly, the intent is for them to limit to themselves the patent, and therefore exclude all others from enjoying this technologically superior product.
Your Honor, with regards to this particular matter, in relation to how our commission and many of our courts would actually decide, we decide with the facts of the case and not mere speculations. I understand, Your Honor, that it may create a monopoly. We may presume that they have an agreement with each other that they will not share it to other patents. But the applicants have failed to prove that such agreement was created. Therefore, we cannot then presume that a monopoly would be created just because they are having the patent amongst themselves. And again, I would like to point out the idea of my co-agent a while ago, that what has happened is out of the greater strategy or the greater commercial strategy understanding of A-Star. To know that the patent is now available, all he had to do is to go to the Middle East, talk with the parent company, and then eventually get the patent. Are we trying to say then that the applicants are arguing that the mere valid and legitimate actions being done by a commercial business is already prohibited and anti-competitive?
Now, counsel, you understand that in cases involving the violation of the Philippine Competition Act, conduct itself is an evidence. The conduct of the parties is evidence, is sufficient evidence, and you do not need the hard evidence as you would as you are alluding to. And so, assuming that there is a monopoly or their intent is to monopolize, then there is exclusivity. You would concede that if that is the result of their conduct.
Your Honor, I agree to your contention. However, this is not present in the case currently. And again, it was not clearly proven by our applicant. Yes, Your Honor.
Yes, Counsel. Oh, well. It's okay. Ladies first.
Hey, Counsel, thank you. Counsel, you have been saying that they are going to pave the way for the use of this. Considering that they are the patent holders, do you think that they can impose as many and as difficult conditions as they want, making that paving the way quote that you're saying more illusory than actually?
Yes, Your Honor. According to the Intellectual Property Code, yes, they may include further requirements. However, again, the facts of the case does not show that. And secondarily, as we were discussing a while ago, in the concept of Intellectual Property Code, they also allow third-party research, which means that the availability of the item in the commercial market does not necessarily require smaller companies to take the patent from Bytech and Chason. All they had to do is buy the item and then do a third-party research so that they too can innovate the market and make the whole industry competitive.
And my next question is, if there is any contradiction between the Philippine Foreign Investment Act, a lot of the provisions of which are permissive, and the Philippine Competition Act, a lot of the provisions of which are prohibitive, don't you think that the PCA rules and regulations should prevail?
Your Honor, an important principle in statutory construction as well is the importance of harmonizing all of the laws. Therefore, I do not believe that there is one that should prevail over the other. And as contended a while ago, the particular matters on prohibited acts are also present in other laws as well. And assuming as well that the current Foreign Investment Act is problematic, we still have the Intellectual Property Code, which specifically shows anti-competitive provisions as well.
Yes, Counsel, just to go back to your earlier point that
Yes, Your Honor.
decisions are based on facts,
Yes,
which
Your
is rightfully so. However, how do you reconcile that with the fact that when you talk about abuse of dominant position, you are looking at conduct that, and this is the exact wording of the provision, that would substantially prevent, restrict, or lessen competition. So, the use of the term would means that it hasn't occurred yet, but that it could likely occur. And I think that might be the argument being put forward, that because of your apparent dominance with the cheaper product, and well, admittedly, probably a better product, that this is where it may end up.
Your Honor, I could see to the idea of the particular commission, because indeed, if there is an anti-competitive behavior that will eventually happen, it may be considered as anti-competitive. But again, I would like to point out that the applicants have failed to do so, to identify. And therefore, it would be problematic for us to presume that such future occurrence would actually happen. And further than that, Your Honor, I also want to contend with moving to the second or the fourth issue rather. Before that, I would like to summarize again that there is no prohibition for foreign investments in this particular case. Number one, the Philippine Competition Act does not have any provision per se saying that foreign investment is prohibited or foreign collaboration. Number two, the Foreign Investment Act shows you that our nation, that the Philippines, welcome and embraces foreign collaborations to improve the market and again to make it competitive. And lastly, that when we talk about the intellectual code, we believe that our respondents rather has been able to meet the statutory requirements. Now, moving further to the fourth issue, Your Honors, we would like to submit that assuming arguendo and giving the chance to consider the speculations and baseless arguments of our applicant and noting it in its highest note, we believe that our respondents have actually also been able to meet the exceptions and exemptions as provided for by the Philippine Competition Act. To be clear, we do not concede to the facts that have been presented by the applicant, but we are only assuming that they are correct in this particular argument. At the backdrop of this particular issue are 2 points. First, Section 14 and Section 15, at the very end of it, actually provides exceptions with regards to the prohibited acts, and Section 21 as well provides for exceptions in relation to mergers and acquisitions. And second, we will also be invoking the forbearance clause thereafter. Your Honors, Section 14 and 15 indeed talks about prohibited acts. It's very clear. And we, the respondents, agree with that. Those are anti-competitive behavior. However, the wisdom of the Philippine Competition Act does not say that mere actions are automatically to be considered as anti-behavior, especially if there are two particular information. One, if that advancement is done due to the business acumen and the better strategy of the company. And second, if that particular change has created valuable benefits for the welfare of the consumers. Your Honors, why should we then assume that there is no business acumen for Biotech and Chason to create a new patent? That by itself was created by their own improvement and by their own research. Likewise, why should we scrutinize A-Star when in fact he was doing it? Because he has found that there is merit to actually reach his goals in terms of partnering with these patent holders. And also, as contended by my partner a while ago, it should be clear that the intent of A-Star was very clear in the facts of the case. During the shareholders' meeting and joining them in the press releases, their clear intention was to help the renewable energy sector. And that brings me to the second point, Your Honors. We're talking about consumer welfare here. The consumers were able to get cheaper and affordable PV units. What is currently better than having the consumers have a better option? Moreover to that, Your Honor, it is also beneficial for the consumer because with the availability of the PV units in the commercial market, as I stated earlier, other competitors may purchase the unit and then be able to create innovations so that more options are given to the consumers in consideration of all of the competitors that are currently present in the market, and even those that are coming in. Yes, Your
Counsel,
Honor.
can you please clarify one point? I hear you talking about the business acumen and superior product exception. I see this in section 15H. Sorry, 15I.
Yes, Your Honor, that is true.
So I don't see this in any of the other sections, in particular on predatory pricing or unfair pricing, and I don't see this in section 14. So do you give me to understand that your point is only limited to 15I?
I understand, Your Honor. If you would allow me to read off from what particular section this argument comes from, that would be for in relation to Section 14, as stated a while ago. It's in under the in Section 14. That would be, sorry, here.
I can see the efficiency
14.
defense in Section 14,
Yeah.
but I don't see the superior skill, superior product business acumen.
Yes, Your
And
Honor.
also, I don't see it in relation to a number of subheadings of 15. So I think we should understand from your argument that your main contention is based on the efficiency defense at 14C and 15. Is it the last 15?
Actually, Your Honors, if you would look at the provided section at the very end of Section 15,
Right.
I would read it for the nothing in this act shall be construed or interpreted as prohibited on having dominant position in a relevant market. Rather, the next one, that any conduct which contribute to improving production or distribution of
Yes,
goods or services.
let me interrupt you. This
Sure,
is
yeah.
the efficiency defense. I
Yes.
understand. This is the
Yes, yeah.
exact same provision that I see in 14C,
Yes.
but this is not related to the superior product or business acumen. So my point is quite simple. Can you please clarify for this panel that your argument based on business acumen and superior product is limited to a possible infringement of 15I, but not of any other subheadings in 15 or 14?
Your Honor, I will concede to this particular fact. Probably we had a difficulty of understanding that particular section. However, assuming arguendo that this particular article does not apply in a whole, we also have what we call as the forbearance clause. Your Honors, to be clear and to clarify to everyone, we know that in the IRR there is a requirement to actively apply for this forbearance clause. However, Your Honors, we would like to clarify that our respondents never thought and never knew that their actions was going to be contended by the applicants as anti-competitive. Therefore, in good faith, they did not think that applying for the forbearance clause was required. Now, Your Honors, if this particular argument does not stand, I would want to invoke the concept of equitable justice. No more than the Supreme Court actually tells us that in cases where substantial rights are in play, procedural rules have to bow down. And in this case, we believe, Your Honors, that there is a substantial right that's going to be protected by allowing this forbearance clause to apply even if the form is not present. And that would be the fair market and also the protection of the environment. The qualifications as identified in the forbearance clause actually is met by the respondents. And I hope that the Commission would actually accept and realize this equitable justice argument. Now, moving to the qualifications, Your Honor. First is that the enforcement of the enforcement of the Philippine Competition Act is unnecessary. To extend further, Your Honor, it's not even about unnecessary. The execution and the enforcement of the PCA is harmful in this particular case. As we have stated a while ago, at the current state, according to the facts, the industry of the renewable energy is in stagnation. And what happens here is that as A-Star creates a new patent agreement, as I told earlier, we are now allowing other companies to realize that they also would be possible to actually get a patent from Bytec and Chesan, so that all of them would be able to create particular products in the PV units that is valuable and cheap and durable for the whole consumers. Further than that, Your Honor, as I stated a while ago as well, having this application would mean that the third-party research would not be done because the items would not be available in the market, because Bytec and Chesan would have the difficulty of actually maximizing the manufacturing of the item. Yes, Your Honor.
Counsel, you mentioned about equitable justice.
Yes, Your Honor.
But do you not agree that you can only apply equitable justice when there is no law in place? And in this case, there is PCA, which forbids unfair monopoly or unlawful combination. How can you apply equitable justice when there is a law in place?
Your Honor, in consideration of the facts that has been stated, what we have to clarify is that right in front of us is a question of trying to implement the Philippine Competition Act because we wanted to promote the concept of competition and for the benefit of the welfare of the people. However, I believe that the Commission would agree with me that if the PCA is not anymore following or is not anymore going to be able to do its role, we should be more liberal in trying to look into the forbearance clause. Because in the first place, Your Honors, I believe that the forbearance clause have been placed there because there is the idea that the makers of this law considers that there might be probable abuses in the future. And that's why, if the qualifications are present, Your Honors, I believe that we have to consider it. Moving further, Your Honors, if there are no more questions, I would go to the second concept of forbearance being not impeding the competition. As explained earlier, the forbearance will allow this particular agreement to subsist. And once it subsists, it opens innovation to the whole market so that it will meet the intention of the Philippine Competition Act itself. We have to understand that the application of the forbearance could be considered as a whole to actually meet the ideology that the PCA wanted to implement. And lastly, Your Honors, is that the forbearance is aligned with improving the needs of the consumers, and lastly, that it would also be good with regards to national policy. There's only 2 points to clarify this. A cheaper PV unit, a durable PV unit, is technically good for the consumer. And secondarily to that, we're talking about the renewable energy sector, Your Honors. We are not only protecting competition, we are also protecting the environment. Your Honors, to summarize and to end this discussion, I would like to tell you a story. 30 years ago, we actually have a group of miners who went to the high courts to actually fight that at some point, commerce has to bow down to the environment. In Oposa versus Factorian, it was clear that we wanted to realize the value of a healthy ecology for the current and the future generations. The applicant appears to paint that the same case is currently here, that we are again fighting between commerce and the environment. But Your Honors, they are wrong. This is a unique case. As a matter of fact, what we have here is a respondent who has been simply following legitimate and valid commercial enterprise with the purpose to actually improve the renewable energy sector. This is if you may please the court a few seconds.
Yes, you may wrap up.
As I was saying, what we have here is a business who recognizes the value of fair market, but without forgetting the concept of the environment. Your Honors, this is the epitome of Oposa versus Factorian. What we have here has already been a win fight. We have already gotten this, and this is what is currently happening today. If we will now go against the respondents, Your Honor, it would be against the will of the children that fought for it and also the children that are yet to be born. Your Honors, right now, if we believe with the respondents, we allow fair and healthy competition in the market, and we also help bring the Philippines into a greener, better, and healthier Philippines. With that, I end our discussions, Your Honor. If there are no more questions, we now defer to our memorials. Thank you for listening, and it may please the court.
Thank you very much, Agent, for the respondent. Per instruction of the Mr. President, we will be allocating 5 minutes for a quick health break for our esteemed panel. And at the same time also to give our finalists some time to prepare the rebuttal and surrebuttal respectively. So could I have 5 minutes on the timer, please? And then we can proceed. Thank you. The bathroom break is for everyone, just to be clear. Not just for our panelists. It's for whoever needs to go, may go. accounted for. To that end, I would like to once again defer to our president for the proceeding regarding the rebuttals and surrebuttals of our participants.
Thank you, Mr. Bailiff. So we begin with rebuttal from the claimant side. Who will be speaking on the part of the claimant? Okay. Yes. So are you ready?
Just a few seconds to gather myself.
Yeah, go ahead, go ahead.
Okay.
Yeah, maybe take a deep breath before you begin. Okay, very good. So if you're ready, you have 5 minutes. You may proceed.
Okay. Thank you, commissioners. Now, we would like to state something clear first. We would like to make it clarificatory. We will submit for ideas here. First is the question of conduct. The second is the question of likelihoods. The third is on the question of the SLC test. And the fourth is on the application of the SNP test made by respondents. With regards to conduct, respondents' conduct and actions have to all be taken together, as we stated before. How respondents have presented their arguments is that they go through each act one by one as if there are separate entities and separate acts that have to be taken in a different way. However, when we look at conduct, when we look at actions, we look at it all together. We have stated earlier, we have to apply the totality of evidence, and that's even applicable in regular procedural law, which to respondents of grace, they did not actually do. So we wish them to address this a bit later on. Now, with regard to likelihoods, the Philippine Competition Act is an interesting law because it's part commercial law and part criminal law. And an interesting part of this also is the wording with regard to how it will apply. There are terms, it's a special law, but there is need for intent here. And intent here does not have to actually have happened already. Because what is the Philippine Competition Act and what is competition law in general looking forward to? It's not just consumer welfare, it's the safety of markets. Do we have to wait for other competitors to be pushed out and for there to be a monopoly of the market before actually applying and prohibiting the other competitors from controlling the market? Do we have to wait until it's something like GrabCore where it's the sole competitor? Do we have to wait for actual harms to happen in order to apply competition law? We submitted to, we do not. Now, with regard to the SLC test, they used it in 14A when it should be in the applications of 14B and 14C, because this is with regard to substitutability, which is in line with the fact with their application of the SNP test, which is a rather strange application with regard to markets. Because the SNP test is used in determining the relevant market and not for mergers. Because respondents are trying to box the claimant, the enforcement office, into stating that these should be in mergers. They are trying to put words in our mouth we did not actually say. We believe that they should have responded to us clearer and with regard to the arguments that we made. If they did not understand it or had a hard time, then we would apologize for them not understanding our arguments. And with regard to that, we would like them to understand that relevant market is necessary in this case. And we wish that they had attacked that idea on whether or not the SNP test is applicable with regard to relevant markets. Now, we also have other ideas here with regard to exclusivity and licensing, because licensing is in itself an exclusive idea. Patents, are an exclusive idea because patents are exclusive. And it's about exclusivity and anti-competitivity. However, it's not exactly a violation because these are within it itself. And that is the nature of licensing and patents. It's not an idea only. It's actually the complete nature of what license and patents are. Further, we have a problem with how respondents keep on adding facts to the case and keep on stating that we have made assumptions. We would concede that there are certain assumptions to be made. However, these assumptions do have to be made since, again, we are looking to protect markets and consumers. Now, to close it out, I just have this idea with regard to their statement on forbearance because their idea of forbearance is rather strange. Because what they had, they should have done is just conceded this idea. The fact that the respondent did not deny any contentions of the claimant is a concession as well. It's quite hard for us to accept certain arguments that they have made because it feels as if they just want to create this idea that there will be further competition when they are pushing out other competitors. We would like this commission to remember competition law is not just about markets and consumers. It is about the total economy of the nation. Because even if we do consider, yes, safety, yes, renewable energy, why would those considerations then apply if what will happen is that there is a degradation and a destruction of the current market? We concede that it is currently and it is presently good for consumers. We concede that it is good for the market right now because there is a low price, durable product. However, we could not concede that it will be better for the future because Section 15 even states it itself. Section 15 states that it would substantially prevent, restrict, or lessen competition. And that is why we submit that this interest in competition law and these provisions should be applied and that it should have been clear in respondent statements how they applied competition law and not just mere policies that they have stated. They should have stated here clearly why the future and why it would not substantially prevent, restrict, or lessen competition. Why the likelihoods in their side will be much better than in our side. Because this is a discussion of likelihoods. This is a defense of current systems and in innovation. To reiterate the idea of low prices, quality, innovation, and choices, and that in these pillars, if even one of these pillars fall, then the market will be harmed irrevocably. And that is why we seek to avoid this to happen. Thank you.
Okay, your time's up. Thank you. We move now to the rebuttal for the, or sure rebuttal rather, for the respondents. Who will be speaking for the respondent? Okay. Are you ready?
Yes, Your Honor.
Okay. You have 5 minutes.
Okay. Your Honor, just responding to some of the new ideas that were provided by the applicant here during their rebuttal. First, they gave us 4 things to respond to, but then in addition later on, a few other things. So first on conduct, they state that we haven't, or rather the respondent hasn't been able to establish that the conduct per se would have been prohibited. However, if the respondent is correct in remembering, their contentions were not necessarily circling around per se violations, which provides for conducts that are violative of competition law. Rather, if we remember correctly, we were discussing about object and effect, which is the intention as well as the effect of the conduct, rather than the conduct itself being violative. So conduct in itself was a non-issue here, because patent sharing on its own, in and of itself, is not anti-competitive. Secondly, on likelihood, they questioned where the market would be safer. And we would also like to pose that same question here. Your Honors, it is our contention that markets will be safer and the consumers would be safer, the economy would be better on our side. Applicant questioned, why is the likelihood on the side of the respondent better than the side of the applicant? And that is what I want to answer for the applicant as well as for the commissioners. The respondent's side, or rather the applicant's side here, presupposes that the presupposes that having intellectual property rights, as the agent stated, would result in exclusivity. And I will quote the second agent here. Patents are an exclusive idea because patents are exclusive, end quote. Hence, it is evident here that what they are forwarding for us is a harmful notion that simply having a patent, simply being exclusive because you had an idea in the first place and you want to protect this idea, you want to be fairly compensated for this innovation that you have made, is already anti-competitive. This is harmful on their end because this notion precludes innovation later on. Innovators that would want to forward their innovations, their technological advances, would be scared to put it out if it would mean they would be penalized by the PCA just for having an innovation and wanting to protect it. On our end, on the respondent's end, we are not only encouraging more innovation, but we are also protecting competitors who would not have access to these patented technologies had it not been for the patent sharing agreement at the end of the day. Because it is true, although the applicant failed to
That
note...
doesn't make sense. Even without the sharing agreement, these are patented matters, right? They could have had access to them because they're in the patents office, right? So the patent sharing agreement did not actually make them public. It's the fact that they're patented in the first place. So the sharing agreement did not enhance that. It did not enhance that to the public because those are already available to the public even prior to the sharing agreement.
Yes, Your Honor, and that's exactly our point. Not only is the existence of the patent inherently pro-competitive for allowing it to be public, but the patent sharing agreement furthers this because it disseminates the PV units into the markets, allowing them to conduct third-party research that it would have been harder for these smaller parties, or rather the smaller competitors, as well as the new entrants to have access if it were just patented at the end of the day. But even if there were no sharing agreement, it would still have been public. And so it is a harmful notion that the applicant is providing for us today, that IP rights or intellectual property law and competition law cannot be harmonized. Further, with regards to the third submission on the SLC test, or the object and effect, as we have discussed, again, nothing was provided by the applicant that it was a per se violation or conduct that was inherently violative of the anti-competitive law. However, they also did not provide us any substantiation as to why they are saying that the effects would be likely in this present case. They have only provided us with assumptions, like we have mentioned. However, they stated that we should give contention, or we should give some sort of note on their speculations here. And we would have agreed with this, and we would have, because we understand that the PCA is indeed a unique law that allows us to look at the likelihood. However, this likelihood cannot be baseless. There must be, at the very least, circumstantial evidence that would help us to, or rather aid us into the conclusion that it is likely. There should have been at least some sort of facts that were provided that would aid us into the conclusion that it was likely for anti-competitive effects to happen. But on respondent sides, we have provided this for you. The mere fact that there was a TTA, the mere fact that there was patent, the mere fact that the patent sharing agreement allowed it to go into the market and be public was already showing that there's no likelihood of an anti-competitive effect, or at least a foreclosure effect, as they would give. Next, on forbearance, they asked us a question of where our competitors pushed out further. And it is our contention that on applicants' end, because on applicants' end, there is no longer any form or any future for innovations later on. Those that want to innovate and those that want to create new ideas and want those new ideas to be fairly compensated on their end would be penalized just because it's exclusive. And that presumptions of possibilities that they would abuse this IP rights is enough to penalize them. We provide, however, on the respondent's end, that is not the case. The PCA is not a cruel piece of law. The PCA, in fact, encourages innovation at the end of the day. Because what they are actually protecting under the PCA is not every single competition. It's not rigid competition, but it is effective competition. And when we define effective competition, it does not include protecting competitors who are not able to innovate, even provided that there was no anti-competitive effects or anti-competitive per se violations or conduct that were present. And hence, them stating or wanting to protect all sorts of competition provides for a rigid and not an effective competition. And with that, we end our note, or we end our submissions for the respondent. Thank you, and may it please the Commission.
Okay. Thank you to the both the claimant and the respondent and the councils. And congratulations to all of you. I now defer to our bailiff and master of ceremonies for the next portion of today's competition. Thank you all.
Thank you very much, Mr. President. And once again, thank you to all the members of our esteemed bench. And once again, congratulations in advance to all of our participants. That was indeed a spirited debate. And once again, I think our judges will again have their work cut out for them. We'll be giving our judges just a few minutes to recollect themselves, to gather their thoughts, and to provide their final score sheets. After which, these score sheets will be briefly tabulated and captured by the organizing team. And then from there, the organizing team will tabulate, provide the tabulations to our judges, and then they will begin their deliberations. On that note, for our members of our esteemed bench, we will be bringing you to judges' quarters, or a holding room, as it were, on the first floor, so that you may be able to discuss and ascertain who wins the first Philippine Moot Court competition law this day, July 21st. So we'll be collecting, if the judges are done, we'll give you a few more minutes. If you're complete with your tally sheets, then we can collect them briefly. And then I will be the one to bring you the final tabulation on the first floor. Ushers, could we bring our esteemed members of the bench to the holding area, to the judges' quarters? And then from there, they can conduct a more lively and thorough discussion as to who will emerge victorious in today's nerve-wracking, as it were, competition. Not just on the part of the participants, but also on the part of the organizing team. So we'd also like to acknowledge our online viewers. Apparently, we have amassed quite a substantial number of online viewers from all over, as mentioned earlier, from all the Philippines, all throughout the world. We've reached, over 1,000? Over 10,000? Over 100,000? Over 100,000 viewers. Wow. I'm sorry. You can type it here, actually. Oh, okay. Oh, just 100. Just 100. Okay, that's a big number in of itself. So just 100 viewers. All right. So judges will collect your tally sheets. We'll provide you with the final tally, and then ushers, kindly direct our judges to where they will conduct their deliberations. As for everybody else, especially for online viewers, please stand by. You'll be seeing this screen for the better part of a few minutes. Rest assured, we'll be back with a decision as to who wins the first Philippine Moot Court competition on competition law. Thank you very much. All right. Good afternoon, everybody. Um, is our bench ready to, Mr. President? We can proceed.
Yes.
All right. Thank you. So, welcome back, everyone, both to our in-person and our online viewers. Before we announce the judge's decision, and with all of the in-person debates having finally been concluded, the organizing team at this point would like to finally and formally acknowledge all of the schools that participated in the entirety of the moot court competition. Preparation of the memorials, the hours devoted to practice for the general rounds, and the mental strength to power through to today's finals and semifinals are undertakings that are a testament to the character and resilience of law schools and law students throughout the Philippines. Now, since this competition prides itself on impartiality and integrity, none of the schools of our participating teams have been made public to avoid any hint of bias or favoritism. And none of the members of the bench from yesterday's finals or semifinals, or even during the general rounds, were made aware of any of the law schools that participated at any point. So we just like to emphasize that. So we're going to take this opportunity to finally acknowledge all the hours of hard work undertaken by all of our participant law schools. From the beginning of the moot court competition until this moment, participating law schools have only been identified through their designated alphanumeric codes provided by the organizing team. The matches and the roles of either complainant or respondent of each of the teams at any point of the general rounds and semifinals and finals were determined through drawing of lots, or as per yesterday, through a coin toss. All schools that submitted a memorial will receive online a certificate of participation to acknowledge all of your hard work and your historic participation in the first Philippine moot court competition on competition law. So are you ready? It is my honor to finally reveal the names of all of our participating schools, starting with the Ateneo de Zamboanga University. Is the deck ready? Okay, hold on, sorry. So for all these are the schools that submitted the memorials. The first is Ateneo de Manila University, Bukidnon State University, University of the Cordilleras, University of Mindanao, Far Eastern University, Xavier University Ateneo de Cagayan, De La Salle University. Next slide. Or is this, sorry. Universidad de Manila, University of Makati, Aurora State College of Technology, Rizal Memorial Colleges, St. Louis University, San Beda College Alabang, New Era University, Central Philippine University, and San Sebastian College Recoletos. Are you ready to announce the general rounds? Is the slide ready? Okay. So these are the top 8 teams that made the cut in the general rounds based on the strength of their memorials. And they will also receive a acknowledgement and a certificate of participation. So our top 8 teams are Aurora State College of Technology, St. Louis University, San Sebastian College Recoletos, San Beda College Alabang, University of Mindanao, Universidad de Manila, University of the Cordilleras, and De La Salle University. With that, these are the next list. Well, sorry, for this point, let's give all of the participating schools and all of the schools that made submitted memorials a round of applause. So with us for the past 2 days are the semifinalists of the competition. Are you ready? All right. So the 4 schools that made the cut
are the Aurora State College of Technology. Let's give them a round of applause. St. Louis University. San Sebastian College, Recoletos. And lastly, San Beda College, Alabang. And finally, after 4 months, I would like to reveal and disclose the identity of our 2 finalists who are now free to post about it in social media. Thank you for your patience. Our 2 finalists are San Beda College, Alabang for the complainant. And for the respondent, San Sebastian College, Recoletos. So with that, we would like to congratulate all the teams who have made it that far. We have received painstaking requests if they can publicize it, but due to the rules, now we can, because we will no longer have any in-person or general rounds for that matter. So with that, before we reveal the winner of today's competition, also the other winners, we'll be having a quick summation of messages from our esteemed panel. I'm sure the value added that they will provide for this day is not just for all of our participants, but also to our general audience, who themselves are budding competition law experts or would want to understand the realm of competition law. So I will call on the judge to proceed. If you could, I will be the one to give the microphone, or if one of our ushers could assist in providing the microphone to the speaker. Thank you very much. So we'll start, for purposes of continuity, on one of our stalwarts on the bench, Chair Emerson Akende, who also served as president yesterday for one of our debates, to give his feedback, his comments, and his advice for our mooters and our participants at large.
Well, congratulations again to all the members of the 2 finalist teams. My only impression at this time is there has been improvements from yesterday to today. I've seen how you performed yesterday and how you performed today. It's much better now today from compared to yesterday. I've also seen how you adjusted your arguments. There were adjustments that you made. As I also noted that you adjusted your arguments in your memorials when you started with your semifinal rounds. And so I'm happy to see that you're very adaptive to your situation. And I think this bodes well for you in the future, that you can improve even better in the coming if there are iterations of this round. I think that will depend on our 2 chairs, whether there will be a second iteration of this, and I hope there is. And so this is a very good start, and coming from I'm not sure if you had your competition law classes already in your law schools. Have you had your competition? Oh, so you had no competition law. Did you have? So both of the teams have had no competition law subject. So you're starting from point zero, and you've taught yourself, and this is a very good start. And I see a lot of improvements, and we understand that you are still groping and you're still having difficulty with some of the concepts that you are presenting, but by and large, you did well, and you did yourselves proud. Thank you.
Thank you very much, Chair Akende. Just for the information of all, just a quick rejoinder, some of the participants are actually freshmen. In fact, some of the some of the semifinalists are freshmen in law school and incoming sophomores. And in addition, just for the clarification of everybody, the top 4 teams that made the general round, that survived the general rounds, were also the top 4 highest scoring memorials. So based on 2 separate and independent assessments of merit, you really did make the cut. So congratulations. So with that, we'd also like to call on our next, the commercial law and academic heavyweight, also known as Dean Cesar Villanueva, to give his message for our participants. Could we pass the mic? Sorry, you have a mic. Sir.
Hello. Well, my congratulations to the teams, to the members and the teams collectively. I want to echo Chair Akende's comment that in spite of the privations that there you have did yourself well. You studied the law carefully, and to Team G, the counsel for the complainant CEO, in spite of the fact that your client has not done a very good job at looking at the facts, you have presented a very credible and substantial arguments to work the best interest for your clients. And to the respondents' counsel, appreciate it very much. You've done very well, and appreciate especially the fact that when interposed an issue by the panel, you're able to directly address them so well. Congratulations to all of you.
Thank you very much, Dean Cesar, Dean Villanueva. Okay, next, for the first of our illustrious international competition law experts, we'd like to call on Mr. Eric Edmondson from the FTC.
Hi. Well, can you hear me? Oh, there we go. First, I wanted to start with the claimant, Team G. I thought it was obvious you've done a tremendous amount of work trying to develop a whole range of legal arguments when to try to deal with or make up for the fact that you really didn't have very good facts to support you. And I want to acknowledge that. I'll just say that I've learned the hard way in my experience of arguing that it's always good to concede bad facts rather than try to stretch the record. So that's one thing that I wanted to pass along. And again, respondent, you did a great job of I think staying focused on the core issues here. You for the most part we're focused on the applying the Philippine Competition Act to the facts. And to be fair, I think the facts were a little bit better for you. I think that I think that was the right thing to do when you were arguing in front of the Philippine Competition Commission. And so I wanted to pass that along. And I want to compliment everybody on your responsiveness to our questions and the way you conducted yourself as advocates under a lot of pressure. So you're all to be congratulated.
Thank you very much, Mr. Edmondson. And as it were, our second equally illustrious international competition law expert, Mr. Mark Waha.
Well, I've been blown away. Very, very impressive. All of you. You all started, we just learned, from a blank sheet. You didn't know anything about competition law a few months ago. I've been trying to understand this topic for the last 30 years, and I still learn things from you today. So very well done. Ivan, a lot of poise, very good presentation, good articulation based on the legal principles, but a bit of a lack of substance in the substantive arguments. Carl, quite impressive, in particular in your responsiveness to the court. Very, very impressive. Relatively good articulation also on the legal arguments, but again, perhaps because the facts were a little bit difficult, you were struggling a little bit more on the substance. I also want to acknowledge the presence of those we didn't hear from today on your respective panels. We could see that there was a lot of teamwork going on, a lot of experience sharing, note-taking, so very well done to you as well. I must make sure I don't mispronounce your name, Heidi. I would not want to stand in front of you in court. Very, very well done. Very, very quick on your feet. Very articulate in your response. But in your initial submission, you came with fantastic ideas and substantive arguments, but you should have articulated them better by reference to sections 14 and 15. This is my main comment. Similar comments, and again, I don't want to mispronounce Abram's name. Extremely quick on your feet, a lot of poise, very well articulated. Little bit weaker on the sort of legal articulation, but your concluding remarks were really, really on point and fantastic. And again, I want to repeat what I said. I acknowledge the presence of the third member of your team. Well done to all.
Thank you very much, Mr. Wah. I truly believe that our participants, and again, all of our audiences, really derived inspiring and very technical insight from your input and your feedback. So thank you very much for your time today as well. So with that, to give a message also to all of our participants, to our audience at large, to other members of the bench, it is my honor and esteem to call on our president for this day, from our no less than our PCC chairperson, the Honorable Michael G. Aguinaldo, to give his message to everybody. Sir, would you stand or? Okay.
Wow. I mean, that's all I can say. Wow. I mean, what you did today and probably the last few months is just amazing. With no training in competition law, so you really start from scratch. And this is not a subject that's easy to understand. When I was taking my master's abroad, I didn't even think about taking antitrust law. Obviously, first reason is we didn't have a real antitrust law at the time. So I said, why bother? And second is because everyone was telling me that, oh, it's so technical, it's so hard, So I said, why will I go through that? We don't even have it here. And even now in the PCC, we learn things every single day. It's nonstop learning and trying to understand all these different concepts and how the landscape is even changing abroad. So for you to be able to stand before us, not just once, several times, and articulate your arguments. Yes, agree with Mark. Yeah, there were some, substantive. But, given that you've never undertook a class on this, all I can say is wow. In practice, one of the things that we would look at when we were hiring people back when I was still in law practice was, this attribute that we call tenacity. What that means is, when you're in front of a judge and you're now getting questions or fielding questions for the judge, this characteristic that you don't fold, that you stand your ground, sometimes even if, you realize your argument's actually not correct, but you still, we fight it because that's something you're looking for, someone who doesn't fold right away. And none of you did. Sometimes the questions were really difficult, but you stood by it, And we could really tell that at the start, all of you were nervous. And that's normal, and that's fine, especially you're faced with an esteemed panel like this. You have two foreign experts, who really know their stuff, and have a wealth of experience. You have, two former, a former chair of the LEB and also a former commissioner at the PCC and the current chair of the LEB, and so there are no slouches, They can, really make it difficult for you if they wanted to. And then you have Dean Cesar Villanueva, who Chairman Emmer is telling me that, oh, your students tell me they're terrified of you. And I was saying that, no, Cesar's not a terror. He's not even considered a terror in the Ateneo Law School. But if he's asking you point blank, it's terrifying because he's very direct to the point, and so you can't BS him. He'll call you out if you BS him. And in fact, Chair Mel, was asking, it's scary to be, the target of his questions. And Mel said, I'm just scared beside him. But to be able to withstand that and to recover, and in particular, I think Heidi, you were able to do that. During the rebuttal, he asked a very pointed question, but you were able to, so all of you being able to answer that way, I mean, like I said, wow, it's really very impressive. I thought it was more than what I was expecting. And so really congratulations to you all. Obviously, there's going to be a winner somewhere, but then, you're all winners. And I'm elated by the fact that once I saw the schools involved, you didn't get the typical, Ateneo, UP, and the like, but you had a lot of schools from the provinces. And I think this really is something that the organizers, and maybe we can give a round of applause to the organizers for all their months' work. It's amazing that you could get participation from all these other schools. It's really good, and it's really heartening, and I hope it really continues. Chairman. And so again, congratulations to you all. Thank you also to the members of the panel for sharing your time and expertise, and of course to the mainly to the LEB and of course the PCC for having this event. Maraming salamat po.
Thank you very much, Chair Aguinaldo. And of course, we, on the part of the organizers, we also acknowledge and thank you for your time. We understand that the time of everybody in this panel, of all of our semifinals and finals, also is invaluable. So, and your insights as well. So, with that, in order to give a final message and a response on her part, as both as a part of the panel and also as a Legal Education Board chairperson, it is my honor to call on our chairperson. Our chairperson is Anna Melanie Trinidad.
Thank you, Attorney Simon. May I repeat the salutations, if only because I felt very honored, I feel very honored to be in the company of such illustrious legal personalities. Honorable Michael G. Aguinaldo, Chairperson of the Philippine Competition Commission, a very, very, very kind gentleman. Honorable Emerson Akende, former LEB Chairperson and former Commissioner of the Philippine Competition Commission. I learned a lot from you from the first time I've met you. Attorney Cesar Villanueva, former Dean of the Ateneo School of Law and former Chairman and CEO of the Governance Commission for GOCCs. Sir, I had looked forward to meeting you, and now I finally did. Mr. Eric Edmondson, Senior Attorney, the United States Federal Trade Commission of the Western Region in San Francisco. It's really an honor to discuss with you and and thank you for accepting our invitation. Same to you, Mr. Mark Waha, Head of the Asia Antitrust and Competition Team, Norton Rose, Fulbright, Hong Kong. Law school deans, professors, ladies and gentlemen, here and online. Good afternoon to each and every one of you. The partnership between the Legal Education Board and the Philippine Competition Commission was forged in order to enhance the knowledge of and appreciation for competition law by policy stakeholders, law practitioners, and law students. Still in its relatively nascent field within the legal community, law schools are yet to establish specific progressions that underscore the complexity of competition law and its interconnectedness with various areas of discipline. Future lawyers who will have immersed themselves in this unique expertise will soon be at the forefront of its practice. The legal acumen to be honed will enable them to navigate this fast-developing legal landscape of this field. Through this moot court competition, we have aspired to bring together legal scholars, practitioners, and law students for meaningful discussions and the exchange of valuable insights. The rigorous nature of this activity has allowed participants to delve deep into multifaceted competition law issues as they sharpen their critical thinking skills and master the art of legal reasoning. On behalf of the Legal Education Board, I extend my most heartfelt congratulations to the finalists of this first LEB-PCC Moot Court competition, and definitely not the last. Your commitment to excellence and resolute pursuit of legal knowledge truly deserve our commendation. We believe that the lessons learned and experiences gained by you throughout this competition will spark your interest in this field and shape your future endeavors. Before concluding, I express my profound appreciation for the organizers of what has turned out to be a very fruitful undertaking. By this, I refer to no other than the diligent personnel of both the PCC and the LEB. Thank you to each and every one of you. To our prominent judges this morning, who had taken time away from their full schedules, your presence alone has added esteem to this event. Thank you very, very much. The faculty advisors, we are continually awed by your steadfast dedication and commitment to promoting legal excellence. Once again, we congratulate the finalists of this Moot Court competition for their exceptional achievement. And to whoever the winner will be, we applaud you for the excellence you have displayed. As lawyers and future lawyers, may we all strive for excellence, uphold the principles of justice, and make a lasting impact on the legal profession and upon our society as a whole. Thank you, and good afternoon to each and every one of you.
Thank you very much, Chair Melanie. Let's give her another round of applause. All right. So with that, to confer the awards for the first Philippine Moot Court competition law, we would like to request our ushers to assist the members of our bench to please stand and to please stand in front of our stage, as it were, for the awarding. Don't worry, judges, you will no longer be asked to climb this mountain of a platform, as it were. All right. So first and foremost, we will now be announcing the winners of the first Philippine Moot Court competition on competition law. First and foremost, we'd like to inform everyone that the general rounds certifications or certificates will be distributed to the participants through online means. So we will kindly wait for them, and then you'll receive them. Okay. Now for our first of our special awards, for the awarding of we have two special awards before we proceed to our for our runners-up and our final winner. For the awarding of the best general rounds mooter, it is my distinct honor and pleasure to call on Ms. Heidi Amabel Uy from Team E, from San Sebastian College, Recoletos, with a preliminary average oral score of 89.08. You will also be given a certification for your participation in general rounds. So among all of the hundreds of mooters that participated in the general rounds, she was deemed the best by our judges. So just some time for a quick picture. Thank you very much, Heidi. Is it correct? And now our next award is for the best overall mooter, and she will be receiving a trophy from the organizing team. The best overall mooter with an overall average oral score of 85.97. Drum roll, please, if we would be so inclined. Once again, Agent Heidi Amabel Uy of Team G. Congratulations. So the overflowing comments and compliments of our esteemed panel are not without merit and substance. Ms. Uy, congratulations. And being hypoglycemic nonetheless. What a feat in and of itself. Thank you very much, Heidi. All right. So at this juncture, we will look forward to the awarding of our second runner-up. And it goes to, drum roll please, the Aurora State College of Technology College of Law. Congratulations to their second runner-up, Ascot, composed of Alyssa May Inhente, Mon Ferdinand Prado, and Eunice De La Torre. Congratulations. Yes, please proceed to the front of the stage. You will also be receiving a trophy, and you will also be receiving a certification and a cash prize. Yes. So congratulations to the Aurora State College of Technology, College of Law. Okay, just for a quick photo. We will be, just to be clear, for the rest of our prizes, we will be awarding them later. All right. Thank you very much. Congratulations to the Aurora State College of Technology, College of Law. And okay, so with that, I would like to announce our first runner-up. May we call on Team G, the San Beda College of Alabang. Congratulations to the San Beda College of Alabang, composed of Ivan Paul Aborot, Carl Emmanuel Divina, and Gian Lourdes Romano, with a total score for the final round from all 6 honorable judges of 1,391 points. So with that, thank you very much. Congratulations for a quick photo opportunity with our esteemed panel of judges. And well, congratulations to the San Beda College Alabang. Congratulations, congratulations. And with that, the cat's out of the bag. Ladies and gentlemen, the overall champion who prevailed over 15 other teams in the submission of memorials, 8 other teams in the submission of the general rounds, and the best of our 4 finalists and semi-finalists yesterday and today. Congratulations, and a heartfelt congratulations indeed, to the San Sebastian College, Recoletos, composed of Agents Heidi Amabel Uy and Abram Andrew Lumbang and Agent Darius Darunday, with a total score of 1,529 points. Let's give them a heartfelt round of applause. Congratulations to the San Sebastian College of Recoletos. San Sebastian College of Recoletos. You will be receiving a school a trophy for your entire team and individual trophies as well. Once again, congratulations to the San Sebastian College Recoletos. And to that, of course, once again, to to Agent Heidi Amabel Uy, who is not only our best general round smoother and final smoother, also won overall for the first Philippine moot court competition law. So with that, thank you very much to our esteemed panel. Thank you very much to our judges. If it please this bench, you can actually proceed to the table so that you no longer have to. You can leave your things here. Don't worry, they're safe. Don't worry. We can just proceed to this table so that we can proceed with our lunch immediately after. Because at this point, we would like to express our heartfelt acknowledgement and gratitude to everybody for having listened, all of our streaming viewers online. And also with that, we will be closing today's finals competition and essentially our first Philippine moot court competition with closing remarks from our principal, Mr. Rodrigo Sagum, the Chief Education Program Specialist of the Legal Education Board. So it's my honor to bring into the stage Chief Rod. Let's give him a round of applause, everybody.
Thank you, Attorney Simon. Ladies and gentlemen, esteemed judges, participants, and distinguished guests, as we reach the culmination of this accelerating moot court competition on competition law, I stand before you with immense pride and an even bigger sense of gratitude. Over the course of this event, we have witnessed the power potential of legal advocacy, the art of persuasive argumentation, and the intellectual rigor required to navigate the complex landscape of competition law. Competition law, as demonstrated today, contains its own nuances and intricacies that serve as a cornerstone of fair and open market. It ensures the level playing field for businesses and provide protection for consumers' interests. With this contest, our participating teams have delved deep into antitrust principles, market dominance, restrictive agreements, and delicate balance between the competition and regulations. Through a rigorous and academic simulation of the proceeding before our esteemed panel of judges, I hope our students have sharpened their legal skills, expanded their knowledge, and developed a profound understanding of the challenges inherent in this field. I therefore extend my heartfelt appreciation to all the participants who have exhibited exceptional legal acumen, dedication, and professionalism throughout this competition. Every one of our participants has demonstrated a relentless pursuit of excellence, showcasing the high standard of legal reasoning, research, and oral advocacy. Your passion for the law and commitment to mastering competition's law's nuances has been truly inspiring. At the end of the day, you have left us with lasting impression that the future of competition law, its practice, and its application have a bright future with minds like yours there to showcase for the betterment of society. I would like to express my sincere gratitude to our distinguished panel of judges. Your expertise, wisdom, and discernment has been instrumental in evaluating the arguments, challenging opposition, and providing invaluable feedback. Your unwavering commitment to fairness, impartiality, and the development of future legal professionals is commendable and greatly appreciated. Your knowledge and experiences have only enriched this event today. With the example you have all set, may it be an inspiration for a new generation of legal minds. In this juncture, I would like to use the opportunity to thank our former chairperson and PCC Commissioner Emerson B. Akende. Sir, from his meaningful time in the LEB until his stint in the PCC, Chair has been a consistent advocate of mainstreaming novel and contemporary areas of legal practice such as competition law into legal education. This is part of his belief that the needs of our country require the most compelling of reforms to legal education. Thus, we thank him for being the empowering bridge between the LEB and PCC, between legal education and competition law, which has led us to the successful hosting of this important undertaking. Chair, thank you. Furthermore, I would like to acknowledge the organizing team who have worked tirelessly behind the scene to make this competition a resounding success. Your dedication to providing a platform for legal education, um, fostering healthy competition, and nurturing the next generation of legal minds is truly remarkable. Without your unyielding support and tireless efforts, this event would not have been possible. As we conclude this competition, let us carry with us the knowledge gained and the friendship forged and the invaluable experience that we shape our future legal careers. Let us remember that competition law is not merely an academic exercise, but a vital tool improving the economic growth, innovation, and consumer welfare. It is our responsibility to uphold the principle of competition and competition fairness, challenge the anti-competitive practices, and contribute to the development of a just and vibrant marketplace. I congratulate all the participants for their outstanding performances, dedication, and resilience. Regardless of the outcome, each of you have contributed to the competition success, uh, to this competition success, and demonstrated the immense potential within the legal profession. Thank you everyone who had made this moot court competition a memorable and enriching experience. May we continue to champion the ideals of competition law, strive for excellence, and make a positive impact in the legal sphere. And best wishes to all for a successful and fulfilling future in the field of law. Maraming salamat.
A round of applause for Chief Rod. He's been instrumental to the execution and success of today's Philippine Wood Court competition law. So with that, once again, thank you everybody. Thank you for the time. Thank you for the willingness that you have had to be with us today, to participate, to put yourself out there for all the participants, and also for our esteemed panel of judges as well. To the organizing teams, I would also like to express my behalf for gratitude for the past months of work. And with that, the first Philippine Wood Court competition on competition law is, I believe, and I would qualify as a resounding success. So thank you, everybody. Congratulations. Once again, this has been Simon Salinas. I have been your MC and bailiff for the past 2 days. So thank you, and see you all in court. Thank you.